All right, peace and blessings, everybody. This is Rudy. It's November the 23rd, the year 2017. I had a few minutes to spare. I've received a huge envelope of investigative materials from a man who is named Thomas Lane in Alabama, who is convicted of murdering his wife. He has maintained his innocence. It appears that this is some portion of the trial transcript. It starts off with page 2106 and goes to page 2218. So that's over 112 pages. So I'm going to try to read 10 pages at a time, and over a period of days, weeks, we'll get the whole thing read into one audio. I tried to scan it, but there's just no way. There's no way I can scan this. It's just, you know, I mean, I could, but it would just, it's going to take me, you know, you have to decide where your time is best spent on this earth. And so if I read it and I record it while I'm reading it, other people can listen to the recording. And then if somebody else wants to scan it, you know, I don't even know how we'd work that. But I don't, you know, it is what it is. Let's get started. Okay, page 2106. And it looks like it's, like he starts right in the middle of something. You know, I guess this was his trial. And I've only talked to him one time. I've sent him some money in access corrections, and I've asked him to call me back. So we'll see if he calls me back. Both the state and the defense. And then I will charge you, and it's likely going to take 30 to 45 minutes maybe to charge you. So with that being the case, we're not going to stay down here until that. We're going to take the weekend off. Come back at 8:30 Monday morning, and 8:30 Monday morning, these lawyers will be ready to summarize their cases for you, and I'll tell you what I think the law is that you should apply in this case. I hope all of you are back so that we don't have to use any of the alternates. So have a good weekend. Stay dry. It's supposed to rain, so stay inside. Don't catch cold. Just have a good weekend. Jury not present. The court. All right. Defense motion at the close of the defendant's case. Mr. Powell, Mr. Powell, we reiterate our motion for judgment of acquittal. The state failed to make a prima facie case as to each count in the indictment. Oh, give me just a second. Okay, the court, all right, deny your motion. Now let me go through the charge with you. It's rough. But both of you have tried cases with, okay, page 2107, tried cases with me, so you're likely familiar with my general charge. But I'm going to talk to them about how they're to consider witnesses and their duties and so forth. I'm then going to specifically tell them about a witness who has been convicted of a felony and how they're to consider that testimony, expert witnesses, law enforcement officer witnesses, the number of witnesses testifying, the defendant not taking the witness stand, circumstantial evidence, how they're to view any statements made by the defendant or witnesses, and what kind of weight they should give that, and how the witnesses were taken under what circumstances. I will certainly define intent and knowingly. I will talk to them about may be formed in an instant and may be formed immediately before the crime. I'm going to charge flight in this case. I'm going to give them a charge on motive. I'm going to give them a very thorough instruction concerning prior acts and conduct of the defendant Lane and how they're to consider that. And it's going to be basically the bottom line limited purpose of motive. Mr. Powell, Judge, that's the limiting instruction we talked about. Miss Rich, that I gave him, yeah. The court, just motive. Mr. Powell, okay. The court, it will maybe a little broader than what the state gave me. Mr. Powell, okay. The court, I'm going to, of course, do presumption and burden and reasonable doubt. I will define basically capital murder. And then I'm going to read the indictment, and I'm going to charge capital murder and commission of a burglary, 1 or 2. And then I'm going to charge a lesser included offense of murder or non-capital murder. You know, some people say regular murder and some people say simple murder, but I don't. There's nothing regular or simple about a murder, but it's an intentional murder. And then I'm going to read count 2, and I will charge capital murder on count 2, pecuniary gain, and also a lesser included of intentional murder. Okay, now I'm going to go to 2109. I'm going to charge them back in count 1 what burglary 1 and burglary 2 is, and frankly I think that's pretty much all. The rest of it is sort of fluff, except telling them about the jury verdicts. Now the jury verdicts is something I'd like, well, first of all, y'all got anything else y'all want me to charge? Mr. Powell, Judge, just for the record, we believe that this jury has heard sufficient evidence from which they could conceivably conclude that the defendant could be not guilty of any aspect of count 1 or count 2, including the lesser offenses. The court, well, I will tell them that. Mr. Powell, I understand, but I say that as a predicate. Give me just a second. I say that as a predicate to what I'm about to say, and that is that there is evidence that there may have been a burglary 3rd degree committed after the homicide. If this jury were to believe that breaking and entering of this residence occurred subsequent to the homicide and that it is committed by Mr. Lane, we think that the evidence would support that conclusion by the jury as well. And we would ask you charge as a, okay, going over to page 2110, as a single lesser but included but separate and apart from count 1 and count 2, the offense of burglary 3rd degree. The court, okay, I think the law gives a judge a tremendous amount of latitude in determining the lesser included offenses can be charged in a case, and certainly I'm very sensitive about that, and especially in a capital murder cases, but I disagree with you. I find absolutely no evidence that anybody burglarized the house the day after the murder, and so I'm going to deny your request. Somebody wrote in pencil here, Judy C. Power closing argument. Oh, Powell closing argument. Mr. Powell, yes sir. The court, anything else from the defense that you would like for me to charge? Mr. Powell, no sir. The court, anything from the state that you can think of that I haven't mentioned? Miss Rich, no sir. The court, okay, the verdict forms are going to be very simple in this phase. We, the jury, find the defendant guilty of capital murder as charged in count 1, or we, the jury, find the defendant guilty of a lesser included offense as charged in count 1, or we, the jury, find the defendant not guilty. The same with count 2. And I think the jury verdict form has become a little different, obviously, if we have to go past that stage. Mr. Powell, yes sir. And the specific language that Your Honor would use in setting out the lesser included offense of murder, is it the court's intention to use the word intentional murder as a description of what the murder is as a lesser included? The court, yeah. And I'll tell them in my charge, Art, I tell them when I define the lesser included offense of intentional murder, I tell them at the end of that charge, please keep in mind that if you find the defendant is guilty of an intentional murder, that they could also be found guilty of capital murder if it's coupled with or connected with a burglary in the 1st or 2nd degree. Mr. Powell, yes sir. Miss Rich, how do we keep them? Let's say they found lesser included offenses on both counts. You can't find 2 intentional murders, could they? The court, well, they could find 2 intentional murders in a capital murder. Miss Rich, right, but there's different elements, but the intentional murders would have the same elements. I'm just thinking out loud here. The court, well, I think we ought to cross that bridge if we get to it. Miss Rich, okay. Mr. Powell, as it stands now, you're simply going to charge them strictly. Count 1 is a capital murder, and these are the elements, and then the lesser included would be intentional murder in count 1, and the specific elements of count 2 with the lesser included of intentional murder, and then not guilty count 1 and count 2. So what? I just want to make sure I'm following correctly. You're saying if we end up with a weird verdict at the end of the case, that we'll deal with it at that time? The court, I think I can probably deal with it. Mr. Powell, okay, I think you could too. All right, that's all. Off the record discussion between reporter and all counsel. 2113. States Exhibit numbers 25-0111-A were marked for identification. States Exhibit numbers 25-0, 59, 60, 62A, 101, 111A were admitted into evidence. Defendant Exhibits number 7, 9, 10, 21 were admitted into evidence. Weekend recess. On March the 14th, 2016, the followed occurred before the Honorable Charles A. Graddock, Ashley M. Rich, Esquire, Tandis L. Hogan, Esquire, present for the state, Art T. Powell, Esquire, and Lee L. Hale, Esquire, present for the defendant. Defendant present. The court. Let the record reflect that the defendant is present with his attorneys. We have been notified that one of the jurors, Mr. Sigler, who was the last juror who was seated in the chair over here, her husband called and said that she has been extremely sick throughout the night with a stomach bug, and we're going to replace her with the defendant's alternate, which would be Thomas Atkins. I don't have a number. Miss Rich, 19. The court, all right. So that means our remaining alternate is Melissa Swindle. Miss Rich, no sir, there's two. The court, okay, Leroy Robertson and Melissa Swindle. Miss Rich, yes sir. Okay, all right. Are y'all ready for closing? Miss Hogan, yes sir. The court, all right. Bring them in, please. The court, good morning. How are y'all doing? How are y'all this morning? Everybody else is okay, I hope. We lost Miss Sigler. She's very sick. All right, ladies and gentlemen, this is the part of the trial that I told you early on where the lawyers argue or summarize their cases to you. They are, in fact, intended to help you understand the facts and the law as they saw it, but of course, it's your recollection which controls. Remembering the lawyers, what they say is not evidence, okay? All right, if y'all are ready, please proceed. Miss Hogan, thank you. Thank you, Judge. Closing arguments. Miss Hogan, ladies and gentlemen of the jury, Thomas Lane is accused of 2 counts of capital murder. 1 count is murder during the course of a burglary, and count 2 is murder for pecuniary gain. I'm going to explain to you now how the state of Alabama has proven beyond a reasonable doubt each and every element of both counts of capital murder, and the defendant stands facing trial today over the past week. The first is murder during a burglary. The state has to prove several elements to prove to you beyond a reasonable doubt that the defendant is guilty of murder during a burglary. First, Theresa Lane is dead. Second, the defendant caused the death of Theresa Lane by drowning her in the bathtub. The third, the defendant intended to kill Theresa Lane. There's 4 additional elements to prove murder during the course of a burglary, and that is that this murder, the top 3 elements, Theresa Lane is dead, the defendant caused her death by drowning in the bathtub, and the defendant intended to kill her. Those 3, plus the 4 elements of burglary, the defendant knowingly and unlawfully remained in the dwelling of Theresa Lane, the defendant acted with intent to commit an assault or murder when he went into her residence, and knowingly and unlawfully remained in her dwelling. While in the dwelling, the defendant, somebody wrote in pencil above the top of page 2117, so event murder in a house equals capital murder. Defendant caused physical injury to any person who is not a participant in the crime. In this case, he caused physical injury to Theresa Lane, and the murder took place during the burglary. The second count we're looking at today is murder for pecuniary gain or other valuable consideration. The first 3 elements of murder: Theresa Lane is dead, the defendant caused the death by drowning her in a bathtub, and the defendant acted intentionally. There's a 4th element to murder for pecuniary pain, and that is the murder was committed by the death for pecuniary gain or valuable consideration. So we're going to go through each of these elements, and I'm going to show you how the state has proven beyond a reasonable doubt both these counts. Theresa Lane is dead. That's our first element. We've proven beyond a reasonable doubt that Theresa Lane is dead. You heard from Dr. Les C. that he performed the autopsy on Theresa Lane. The cause of death was drowning. The manner of death was homicide. He went through each and every injury that Theresa Lane sustained. Page 2118. He talked about how she had petechia in her eyes because of the asphyxiation that occurs during drowning. He talked about how she had fluid and froth in her lungs and sinuses, telltale signs of drowning. He also talked about the blunt force trauma that he found on Theresa Lane's body, multiple contusions, which are bruises, abrasions, which are places where the skin tears on Theresa Lane, her arms, her forearms, elbows, knees, head. He talked about all those injuries, but he ultimately ruled that the cause of death was drowning and the manner is homicide. So the state has proven to you beyond a reasonable doubt that Theresa Lane is dead. So check that off your list. The defendant killed Theresa Lane by drowning her in a bathtub. We already know that she was drowned in the bathtub, and Dr. Les told you that was the cause of death. The defendant is the one that did this, and I'm going to tell you how we've proven that the defendant is the one that's done this. There's a lot of evidence in this case, and you guys have heard from numerous witnesses. There's a whole cart of exhibits over here that you're going to get and take back with you in the jury room. And the judge is going to instruct you what circumstantial evidence is. And there's some circumstantial evidence in this case. I'm going to go over that with you real quick. It's given the same weight as any direct evidence. And then somebody wrote in parenthesis, lie. So any evidence that's direct is given the same exact weight as any circumstantial evidence that you look at. And then it writes, somebody wrote in pencil, only if direct evidence, eyewitness James J. is direct evidence. And the example that the judge usually gives, and I'll give it now so that you'll hear it twice, is if we're all sitting in this room and we're not able to look out a window, but you know that there's a witness that comes in from the back and who has a raincoat on that's wet, an umbrella that's wet, and you hear thunder, you can use those circumstances and those facts that you observe to infer that it is raining, okay? You may not see the rain, you may not be able to look out the window and see the rain, but you can use those facts and circumstances to determine that it is raining outside. And that's what circumstantial evidence is. It's the kind of 2120 evidence from which you can infer other facts. So you can look at all the evidence and infer other facts using your common sense and your lifetime experiences. I'm going to go through a timeline of events because all these facts and circumstances are what led up to us proving beyond a reasonable doubt that the defendant is the one that committed this murder. This is the one that went into the house and drowned Theresa Lane. We'll start in July 2003, and that's when things started to get rough between him and Theresa. You heard from the witness stand that they got married in 1995. And that they'd been married for about 8 years. And in July of 2003, Theresa moved out. And you heard from Nadine Hildesheim that she helped her go over there and get her things. The police were called. She moved out of the residence and started to initiate these divorce proceedings. Theresa goes to Ronnie Williams and files for a divorce July the 3rd, 2003. You heard from Ronnie Williams, this is in evidence, missing June 21st, 2003, Ben Forsert as form. That was in parentheses, by the way. Okay, bottom. On July the 11th, Theresa changed her life insurance policy beneficiary. She went to Walmart. Okay, I'm going to stop here at the top of page 2121 and we'll resume at the top of page 2121. Okay, I'm going to try to knock out another 10 pages of Thomas Lane. We're going to start at the top of page 2121. She went to Walmart and she had $150,000 in life insurance and she changed her beneficiary to her sister Miriam Mahoney. 100%, all of the proceeds from her life insurance was to go to Miriam Mahoney at that time. July the 14th, the defendant opened his own bank account. Hold on, let's see the dates again. Okay, she did that on July the 11th. July the 14th, the defendant opened his own bank account. July the 16th, the defendant saved a picture of Lorna Abe to his computer. And this is when the defendant starts getting involved with Lorna Abe 2 weeks after his wife had moved out of his residence. The defendant first wires Lorna Abe $500 on July the 22nd, 2003 with his Western Union account. He then wires another $500 to her on July the 26th. On July the 28th, the defendant writes a letter to Ronnie Williams, the wife's divorce attorney, to get this over with. He's ready for the divorce to be over. And you heard Ronnie Williams talk about how the defendant would come to the office, would remind him how long he said it was going to take. You said this was going to take 6 weeks. Why are we still waiting on this? He was ready to get the divorce over with. On July the 28th, okay, now I'm at the top of 2122. On July the 28th, the defendant also wired Lorna Abe another $500. On July the 30th, the defendant sent flowers to Lorna Abe. And you heard the message that we read into evidence that he wrote her at that time. On July the 31st, the defendant cancels Theresa's plane ticket to the Philippines, but kept his own ticket to pay for deposits to turn on the utilities Theresa and Celel. I can't read. Some of these things are in pencil. It's hard to read. Moving to August 2003, Theresa has been out of the home for about a month, living with many different friends, taking different routes to work, trying to avoid the defendant. On August the 8th, he applied for a phone for Lorna Abe, and that cost approximately $1,900. Somebody put in parentheses, "Paso, not money." I don't know what that means. That receipt is in evidence. On August the 15th, the defendant's bank account was overdrawn. On August the 17th, the defendant turned Theresa's truck into Aubrey Mixon at the Nissan dealer. And you heard multiple witnesses say that he would go and take her truck as a carrot, as something to dangle over her head to say, "Hey, hurry up and sign the papers." That's what Ronnie Williams said. 2123. He took it to Aubrey Mixon at the dealership and was complaining about his divorce, complaining about his wife. You heard the testimony that Aubrey said, "Well, you can't live with him and you can't live without him," like referring to women. And the defendant said, "Yeah, the only good woman is a dead woman." On August the 18th, the defendant's account is overdrawn again. On August the 18th, that same day, he wired $333 to Lorna Abe. Look at the deposits are over. On August the 30th, 2003, the defendant filed for alien petition for Lorna Abe to come over and be his fiancée. And you heard from the Border Patrol officer, William Jordan, that he had to attach documents to that. So he had to attach his certificate of divorce from his prior marriage and all the things to verify that he was eligible to bring another fiancée over here. And you heard him, and you heard Officer Jordan testify that the stuff wasn't done. None of that was attached, and he was unable to process it at that time. Moving on into September 2003, Theresa is still living outside of the residence. They're still trying to get divorced. The divorce has been contested, and it has been contested since he, page 2124, started taking over her vehicle and wouldn't give it back and was parking it in weird places. And you heard that. On September the 3rd, 2003, the divorce petition is actually filed, so it takes some time to get all that together, and the divorce is actually filed with the court. So, not a reason to kill Theresa, since filed. Should have killed Judge, not Theresa. September the 4th, the defendant wires $80 to Lorna Abe. September the 9th, $200. And on September the 18th, his account is overdrawn again. The 22nd, he wires $50 to Lorna Abe. The 23rd, the motion for the return of the truck is scheduled for October the 15th, 2003. So in about 3 weeks, they're going to hear that motion that the divorce attorney filed regarding the truck, okay? September the 27th, another wiring of money to Lorna Abe. Now, this is about 1 to 2 weeks prior to the murder. A lot of witnesses came in and said it was about a week before the murder. It was about 2 weeks before the murder because, you know, they didn't take it down, and that was their point of reference, so I don't have an exact for you on that. But 1 or 2 weeks prior to the murder, this is the top of page 2125. But 1 or 2 weeks prior to the murder, Jerlene Gilmore sees the defendant's truck in Walmart parking lot, and you heard her testify that he got out and was walking with her into the store, and she was scared. He made her uncomfortable. She wanted to get away from him. She had testified that she had seen bruises on Theresa in the past and that she was not comfortable with the defendant. She would take multiple routes to Walmart to try to lose the defendant so the defendant could not find out where Theresa was living. Renata Cross said she saw the defendant in Walmart during Theresa's shift several times. The first time she said that the defendant was looking for Theresa because Theresa used to do the baby food, and he was wandering around, and management calls Renata and says, "Go take care of this." Renata contacted Theresa. Theresa didn't want to see him, and so at that time Renata had the security officer escort him out of Walmart at that time. And then later, somebody wrote in pencil to drop of $50 to Theresa on July the 28th. And then later, 1 to 2 weeks prior to the murder, the defendant comes back to Walmart looking for her. And she said at that point he had already left. She didn't actually contact him, but she saw him there. Page 2126. The defendant shows Marshall Bowers a picture of his new bride, and we've shown you this picture multiple times. It's in evidence, but he is telling everybody that this is his new bride, and he's bringing her over here from the Philippines. He's working on his visa financial arrangements with her father, and Marshall says, well, don't you think you ought to get divorced first? And the defendant says, you know, I'm going to have to worry about that much. I'm not going to have to worry about that much longer. B.I. hired Buzz. Anthony Basil testified that the defendant told him that he would kill Theresa if he could get away with it, and that was 1 to 2 weeks prior to the murder. And you heard the testimony from Mr. Basil. On October the 2003, the month of the murder, the defendant's petition for alien fiancé for Lorna Abe is received on October the 3rd, and you heard from the Border Patrol officer that it wasn't valid because the documents weren't attached, but it was received at that time. On October the 6th, a receipt for a $500 check for attorney fees was issued to Mr. Lane. Okay, I'm going to stop on the top of page 2127. The top of page 2127. All right, picking up at the top of page 2127, we're going to try to read 10 pages. On October the 9th, the defendant's account was overdrawn. On October the 10th, the defendant's account was overdrawn. On October the 11th, the defendant goes to the Brunos and asks them to keep his dog so he can go to the Philippines and get his new bride. And you heard that from both Scott and Melissa Bruno that he came over the night before. That was a Saturday, and asked them to keep his dog. On October the 12th, 2003, the day that Theresa is murdered, the defendant is on his computer from 4 a.m. until 6:35 a.m. And that's on the internet, using the internet. We have records of that. You heard Marty Irvin talk about how he can tell when someone is using the internet when they're there. And remember back in 2003, it's not like we are today where we've got the internet everywhere and we go, and I'm probably on the internet right now even though my phone is turned off. Back then you had to sit down and dial up and get on Netscape, Navigator, or AOL and wait. And then if somebody wrote in pencil, lie, I had Bell South DSL. So we know the defendant was at his residence at that time because he was on the internet. Page 2128. Theresa clocks out at 7:03 a.m. and that was Theresa's shift since 2000. So she had been doing that night shift for 3 years. 2 of those years, or the majority of that time, was married to the defendant, okay? So he even took her to Walmart to apply for the job. So he knew what her hours were. He knew she worked in Tillman's Corner. He had seen her there. He has been going to the parking lot to take her. He has been going to the parking lot to take her truck. He's been watching and knowing what's going on ever since she moved out. Pam Halbrook drops Theresa off at 7:35 a.m. She described to you how she drops Theresa off. That Theresa would always go in the back door. They never used the front door, but she always would walk around to the back. And she told you exactly what she was wearing that day. Remembers the last time that she saw her friend get out of the back seat of the vehicle. Kim Bauer saw the defendant between 7:30 a.m. and 8:30 a.m. And she remembered that because her daughter was graduating from boot camp, if you recall, and her sister was coming to pick her up, and she knew she was waiting about 7:30 to 8:30, but she knew it was before 9 a.m., okay? That was, and then somebody writes in pencil, my second trip to Chevron did not see Bruno's leave. Okay, page 2129. That was her testimony. Melissa Bruno saw the defendant leave at 8:15, and somebody wrote in pencil, 3 minutes to 8:30 equals 8:27 a.m. And she was out. Her trailer is the one that faced the defendant, and she was out smoking a cigarette before she went to church. Church started at 8:30, and she was smoking a cigarette waiting for her husband to come. She saw the defendant leave at that time. Forward, and then somebody wrote in pencil, forward me to Chevron gas station or something. Scott Bruno said he saw the defendant leave before they went to church. He didn't give you exactly 8:15 or whatever, but he knew that the defendant left before they left to make it to Mass at 8:30. There's a 17 to 19 minute drive to the 15th Street in Irvington, and then somebody wrote in pencil 34 to 38 round trip. That was testified to by Mitch McRae. And he actually went out and drove on a Sunday around the same time to make sure that the timing is correct. So 17 to 19 minutes is how long it took the defendant to get to 15th Street in Irvington from his residence. And Melissa Bruno said she saw him leave at 8:15 in the morning. So he's on the move at this point. State's Exhibit number 42. This is the pea green 1970s Ford truck that the defendant drove in 2003. License plate Captain Tom. And page 2130. And 3 witnesses in the trailer park saw him leave in this truck. The next thing we see, James J. sees the defendant pull up in the truck, lime green and not me. It was 120-pound guy, lie, not equals not me. Sees that the truck come down 15th Street in Irvington and Park, and he watches someone get out of the truck and go into the house. Notices the truck because he is a mechanic. He worked on vehicles his whole life. He knew it was a 70s model Ford. He said, I noticed it because it had a very distinct color, okay? So he noticed that that truck that morning about 8:30, and that was what the testimony was. Theresa Lane is murdered. Okay, and then someone wrote in pencil, Bronos, Sapie left 3 minutes before 8:30 equals 8:26, 8:44. Arrive on COP 8:54. At 9:30, when the Brunos get back from church, both Melissa and Scott saw the defendant's vehicle at his trailer, and that's about 9:30. An hour after James J. saw the truck pull up to Theresa's residence. 9:45, the defendant changed his wallpaper on his computer, and we know that from Marty Irvin, he changed it from State's Exhibit 82 to State's Exhibit 83. The photo of him and Theresa, and this is another photo that he changed it to. So we know he was back home at 9:45. 10:10 is when Indy Wilson called 911, and you heard the panic 911 call from Miss Wilson. Page 2131. And that's when she discovered her friend in the bathtub. The defendant then goes to Tony, Bing Basil's house after that morning. Bing is at church. She gets home about 12:30, I believe is the testimony. And the judge is going to tell you what I say is not evidence, so use your collective recollection on those times. This is my summary of that. That same day, the defendant asked Melissa, Scott, Kim Bowers, Marshall Bowers, and Susan Hodges for an alibi. Says, do you remember seeing me this morning? My wife's dead. 87% of women, this is in pencil now, 87% of women killed in the world are by their boyfriend or husband. My wife's dead. They're going to look at me first. Don't you remember I told you I was going to get coffee and donuts? Do you see my truck? Did you see my truck this morning? Did you see me before you left for work? All those questions are asked by the defendant after the murder on the same day. The defendant makes arrangements for cremation. In pencil it says, if I do this, who is going to do? If I did not do this, who is going to do? Then the defendant calls Chaplain Ron Pierce and asks about how to get that insurance money that day. He's not calling for grief counseling. He's calling to ask, how do I get insurance money? Page 2132. After I went to the funeral home and found out how much it cost, the call 15 minutes, what else did I say? And remember, Chaplain Pierce said that was unusual. Most of the time they don't ask me right away, and I told him we'd look into it and I'd help him because that's his job to help victims' families, okay? And at that point, this investigation was a death investigation. The defendant goes to Walmart to collect on the life insurance policy the very day that Theresa Lane is found murdered. The next day, the defendant is on the computer at 7 a.m. chatting with Lorna Abe. 8:30 is when the autopsy revealed the cause and manner of death. So at this point, 8:30 on October the 13th is when the Mobile County Sheriff's Office realizes this is a homicide. And you heard Detective Mitch McRae say, we got in there and there were bruises. There was defensive wounds all over the place that they didn't notice the day before when she's in the bathtub and they're doing all this other stuff. But there were all these defensive wounds, and we changed our opinion at that time from maybe this could have been an accident to there was no accident, and that occurred at 8:30 the next day. The defendant paid $1,000 cash for attorney's fees that day. October the 12th, the defendant gets information on cremation, page 2133. And the defendant for the second time goes to Walmart to collect on the life insurance, and this time he meets with Debbie Gable. You heard Debbie's testimony. He came in nonchalant, acting normal, wanted to know about life insurance, and she said, "You're not the beneficiary," and he left at that time. That day he got arrested. He had $300 cash in his wallet, and he had latex gloves in his pocket. And the sheriff's office goes back to the crime scene that night, as you heard through the testimony. At that point, when they got the autopsy, they went back to the crime scene because they knew that this was a homicide investigation. October the 15th is when the defendant's bank account is in the negative over $200. The search warrant is conducted on the truck and on the defendant's home. Screwdrivers and chisels are taken into evidence on that day, October the 15th. And the 16th is when Indy reports her jewelry is missing. And then somebody wrote in pencil, but Theresa still had her necklace on. November the 25th is when the door is taken into evidence. Page 2134. And at some point the defendant confessed to Wayne Dewitt that he murdered his wife in the bathtub. And he did that in October after he was arrested, but before Wayne was sentenced on November the 6th. So all those events, all those are facts and circumstances that lead up to proof beyond a reasonable doubt that the defendant is the one that killed Theresa Lane in the bathtub. Hold on, I got to put a... Give me just a second. I'm going to look for a sticky note because they're saying in closing arguments that he confessed to Wayne Dewitt. I want to know if that's true. So all those events, all those facts and circumstances that led up to the proof beyond a reasonable doubt that the defendant is the one that killed Theresa Lane in the bathtub. The defendant's chisel was used to pry open the door to get into the residence, and that defendant's chisel was found in his truck 2 days later. And you heard Scott Milroy's testimony about how the tool mark was compared, and that every little ridge and groove is a unique characteristic of that chisel. Somebody wrote in pencil, cannot say what day it happened. Okay, he said that there are class characteristics, which would be the width of the chisel, and there are 3 marks on the door that have the same class characteristics. So the same width of the blade, but number 3 for their purposes was one that had the individual characteristics that they were able to compare every little groove. And every time you use a tool, every time you nail a nail in a wall with a hammer, every time, page 2135, you take the chisel to scrape something, you're marking that tool. You're making an individual mark on it. In this case, Scott Milroy said without a doubt, this is the one unique tool that made this mark. The defendant intended to kill Theresa Lane. And what we're talking about is, did he mean to do it? The intent factor. Because I have to prove to you, the state has to prove to you beyond a reasonable doubt that the defendant acted with intent. Okay, I'm going to write a little note here. I want to know about this confession. The confession on page 2134. And I want to know about this tool mark on 2134 and 5. So that's something I'm going to ask Thomas about. All right. Intent may be formed in an instant. It's not something that has to be planned. It doesn't have to be premeditated. As soon as you form the idea that you want to do something, you have intent. It can be 2 seconds before you do it, or it can be months before you do it. It can be formed in an instant. It doesn't have to be formed in advance of committing the crime, okay? And it can be formed immediately before the crime was committed. Intent to kill must be real and specific, and the judge is going to define intent for you. A person acts intentionally with respect to result or conduct when his purpose is to engage in that conduct or cause that result. Page 2136. That's the legal definition. That's a lot of words, but what it means is, did he mean to do it? Did he mean to kill Theresa Lane? And we can look at what he did to see what he meant to do, and all the facts and circumstances that surround what he did to see if he intended to do it. You look at all the evidence and all the circumstances to see if he intended to kill Theresa Lane. The defendant has a history of violence against Theresa. And then in pencil mark it says no evidence. That's a fact and circumstance you can look at to determine his intent. You heard Jerlene Gilmore, numerous witnesses, and then somebody put in parenthesis only 2, say that there were bruises on her, that she was scared of him, and that she didn't want him around her. Somebody else wrote in parenthesis, pissed at me. She wasn't scared of him, but she was pissed at him. But her best friend never her on saw, and he has a history of violence against her. The defendant found a new bride. The defendant was continually trying to speed up the divorce to get it over with and to get Theresa out of his life. He steals her truck. He stalks her to find out where she lives. He's wiring money to Lorna Abe for 3 months before this happens. He's negative in his bank account. He tells neighbors and friends that about his new bride, and he wants that, page 2137, he wants that insurance money. Look at what the defendant has said to see what he intended to do on October the 12th, 2003, and all the testimony. You heard several statements that the defendant made regarding Theresa, and all those are evidence and circumstances that can lead you to infer intent of a defendant. The only good woman is a dead woman. He said that to Aubrey Mixon when he was turning her truck in. If I could do what Peterson did and get away with it, I would. What did Peterson do? He murdered his wife. If I could do what he did and get away with it, I would. I'll just run her off the road. That's what he told Tony Basil after they watched that true crime detective show where the guy murders his wife and got some insurance money or wanted insurance money. He said if I could get away with it, I'd do it. I'll just run her off the road. He told Tony Basil I'd put 3 bullets in her head if I thought I could get away with it. And you heard Jerlene Gilmore say that she heard a voicemail from the defendant to Theresa that said, I love you and I want you back. But if, page 2138, but if you don't come back, you'll be sorry. And he told Marshall Bowers he wasn't going to have to worry about getting a divorce the day before he murdered Theresa Lane. And somebody wrote in pencil, because I hired Buzz. What actions did he take on October the 12th that show his intent to kill Theresa? First of all, he got in his truck and he drove to her residence. He made a choice to get out of his house and get in the truck and point his truck in the direction of Theresa Lane's residence, intending to kill her. Intent right there. He parked on the opposite side of the street, and James J. saw him get out of the vehicle. And then in pencil mark it says 120-pound guy, not me, and go to the house. And every time making a choice to kill Theresa Lane, he used a chisel to pry open the locked front door. That chisel was found in his truck. He had to pry it open. He had to use some force. And you heard the defense ask Scott Milroy, well, it'd be really hard to get that open. There's molding, and he might have had to use another hammer. It may be. That was what Scott Milroy said. He said, yeah, that would be hard to do. In parenthesis or in pencil, it says, how much time? Every time, every second he was doing that, he was making a choice to enter that residence and to, page 2139, kill Theresa Lane. Holding Theresa in the water, and then in pencil it says, no black and blue marks on Tom. Holding Theresa in the water as she struggled, and you heard Dr. Les say that there were wounds all over Theresa's body. And you saw, and then in pencil it says, if fighting with her also there should be black and blue marks, but none on me. And you saw the diagram. He said they were all over, as you could see. They were all over from her ankles to the top of her head because there were bruises and scrapes and cuts. States Exhibit 31, these are the contusions on Theresa's head and the back of her head, and she was being held under the water and struggling. Thomas Lane held her down, intending to kill her, causing these bruises to her head. States 32 bruises on the elbow, and there's an abrasion there. Struggling for life, the defendant held her in the water, making a choice and intending to kill her. There's a bruise on her ankle, 36. Bruises around her neck, on her shoulder, as he held her under the water, intending to kill her. And I submit to you, ladies and gentlemen, that the evidence has shown that she struggled during that, and that she wasn't how long going without a fight. And he held her long enough for her lungs. Somebody wrote in pencil, I guess it was Tom, no black and blue marks on me. Okay, page 240. To fill with foam, her sinuses filled with water, and for her to eventually die of asphyxiation, all the while intending to kill her with every conscious choice he made that day. After she was murdered, the defendant did some things that also showed his intent. He went around asking everybody to cover for him, alibi request. Remember, you saw me this morning to get coffee and donuts? Would you testify against me? Scott Bruno, because the cops is going to try to pin this on me. In pencil, oh, because the brother is going to try to pin this on me. But somebody wrote in parenthesis over brother, cops, and then in another pencil mark they say not in evidence. To Marshall Bowers, the defendant asked him if he would tell the police that he saw him that morning. And Marshall said, I'm not going to lie for you, because he said he didn't see him. He said he's not going to lie for him. Susan Hodges, the defendant, asked her if she saw him that morning, told her he got donuts. And he said, I'm probably going to need an alibi because they're always looking at the husband first. The defendant told Mitch McRae he was on the internet chatting during the time of the murder. We know that's not true. We know that from the computer record. Defendant told David Lott that the scratches... Okay, I'm going to stop here on the top of page 2141. Okay, the top of page 241. Defendant told David Lott that the scratches on his legs and back were from his cat and from diabetes. Now, the defense is going to ask you to consider a lesser included offense, and that's just murder, plain old simple intentional murder, and they're going to probably ask you to consider that. Where are we at? Okay, here are the three elements of murder. The first three elements of both counts of capital murder. The first three, Theresa Lane is dead. The defendant caused her death by drowning her in the bathtub, and the defendant acted intentionally. Have we proven murder beyond a reasonable doubt? Has the state proven to you murder beyond a reasonable doubt? Yes, we have, but we have proven more than just the elements of murder, more than just the elements of murder. Murder during burglary, top three, murder. That's all you need for murder. But what do you need for capital murder? These additional four elements, and we've proven to you beyond a reasonable doubt, so murder plus burglary. The defendant knowingly and unlawfully entered and remained in the dwelling of Theresa Lane. The defendant acted with intent to commit a crime, namely assault. Page 2142. Namely assault or murder when he entered and remained unlawfully in that dwelling, and while in the dwelling he caused physical injury to Theresa Lane, and the murder happened during a burglary. Okay, those four additional elements, and we've proven those beyond a reasonable doubt. She moved out July 1st, and somebody put in pencil June 16th, 2003. She would stay with people to avoid the defendant. The defendant told Paula LaPointe that he figured out where she lived, that he had followed her enough to figure out where she lived. Indy Wilson testified that the defendant had knocked on the door prior to the murder and they would not let him in. They would not let him in. They didn't want him in there. They were scared of him. They actually left the house and spent the night somewhere else. That was prior to the murder. The chisel found in the defendant's truck was used on the front door. And then in pencil it says cannot say what day. All of those things go to show that this murder that I've already proven, that the state has proven, those three elements happened during the course of a burglary. The defendant unlawfully entered dwelling. He knew he was not invited. He was not welcome. He had no claim to be there. We know that because Theresa tried to get away from him. Theresa stayed with different people. Theresa and Indy were scared when he knocked on the door. They would not let him in the house, and he used the chisel to pry open the door. So we know that he entered and remained unlawfully in that dwelling. We know that he caused physical injury to Theresa. You've already seen that. He murdered her, okay? That's proven beyond a reasonable doubt. All the 4 additional elements of murder during a burglary are proven beyond a reasonable doubt. So this isn't just murder, this is capital murder, murder during a burglary. Murder count 2 for pecuniary value. First 3 elements, same, murder proven beyond a reasonable doubt, an additional element. The defendant committed the murder for pecuniary gain or other valuable consideration. Now, we don't have to prove motive to you, and the judge will tell you that. Motive is why somebody does something, and we don't have to prove, page 2144, that beyond a reasonable doubt. In this case, we know why, and it's for this pecuniary or other valuable consideration. We've proven that. We've proven that by his actions. The same 3 elements of intentional murder plus the 4th element. Murder was committed for pecuniary gain. We know that through all the other evidence of motive that we have gone through when I went through this timeline, when I've gone over everybody's testimony. The defendant called Chaplain Pierce and wanted to know about the insurance right away, the same day. The defendant went to Walmart and asked for the insurance money right away, the same day he murdered her. The defendant went back to the following day to collect on the life insurance policy the next day. He had a negative balance in his checking account. We know he's been wiring money to Lorna Abe. He paid $1,000 in cash to his attorney. And then in pencil it says, but never checked my other bank accounts. He had $300 in cash in his wallet when he was arrested, and he had plans to go back to the Philippines to get his new bride. He had to make, page 2145, financial arrangements for that, and he had already done all these payments. He had gotten this far. He had made it to September the 27th. He paid all this money, set up a phone, had his plane ticket. He knew he had to go in December, and the divorce wasn't just moving fast enough for him. He did it so he could get the insurance money. He wrote numerous letters to Ronnie Williams asking him to speed it up. He took her truck, brought it back. In pencil it says, it's hard to read. Science deposed, filed. I was waiting on the judge, not Theresa. I don't know, I can't read it. Not Theresa. Oh, since divorce filed, I was waiting on the judge, not Theresa. States Exhibit number 96, this is when she changed her life insurance. Her spouse, none. On July 11, 2003, Theresa said she no longer considered herself having a husband. 100% of the proceeds was going to her sister. On September the 3rd, this is when the divorce petition was filed. It hadn't been set yet. No trial set yet. The only thing that was set was the hearing on October the 15th. The defendant running out of time. He was running out of money. Miss Rich told you that the money is the root of all evil, and that's how she opened this case. The defendant bought, and then somebody wrote above this, lick not in evidence. The defendant bought and paid for Theresa Lane, and she wasn't willing to live up to her end of the bargain in his consideration. She was, page 2146, she was Americanized. She had moved out. She wanted more than what he was given her. And he was ready to replace her. She was an object to him. She was something that he had already bought, shipped over here, and she wasn't living up to her end of the bargain. And so what did he do? 2 weeks after she moved out, he made plans to replace her with a younger girl that he hoped would be submissive and obedient like he hoped she was going to be before she got too Americanized. Not in evidence, is what he wrote in the side. And when the divorce was filed, it wasn't fast enough. Within 3 weeks, he was taking her truck. He was going to the divorce attorney. Hurry it up, hurry it up. I've got a replacement wife coming from the Philippines. I've paid for her. I need more money to pay for her. And when he ran out of money, he took something that was disposable to him, killed her, strangled her. And then he writes, not in evidence. No marks on Theresa's thought, though. Held her under the water while she breathed in air and foam into her lungs until she died so he could get that money to bring his replacement here. The defense is going to ask you to consider just murder. This is capital murder. We've proven all the additional elements of capital murder. Page 2147. During the course of a burglary and capital murder for pecuniary gain through all of the evidence, circumstances, and facts in this case, at the end of this trial, we're going to ask you to return verdict of guilty of murder during a burglary and murder of pecuniary gain because we've proven all those elements beyond a reasonable doubt. Thank you. Mr. Powell, may it please the court, Miss Rich, Miss Hogan. Good morning. It's a little earlier than we'd like to be doing this according to my body clock, but we're going to. We've been at this for a real long time now. This is entering the third week. You've been very attentive. We appreciate that. As the judge told you when we started this, you folks are the judges of the facts, okay? You decide what the facts are. What the true facts are. The judge will instruct you on what the law is that you're to follow. But you folks will apply the facts as you've heard them from the witness stand, and maybe some of the things you didn't hear come from the witness stand in reaching your conclusions. Page 2148. Now they get two opportunities, they meaning the district attorney, they get two opportunities to argue their case to you, and the reason for that is they have the burden of proof. They have the complete and total burden of proof. The defendant, Tom Lane, does not have to prove anything to you. So as you go through this process, remember that, okay? And I will point out a lot of things for you today, a lot of questions, a lot of issues, a lot of what I'm going to call reasonable doubts. And by the end of this, you will see. A trial is supposed to be like a puzzle, okay? And all of the pieces have to fit. And if all the pieces and all of those if all of those pieces don't fit, then the puzzle is not complete. Well, the missing pieces of a puzzle is a criminal case. Well, the missing pieces of a puzzle in a criminal case can be anything that causes a jury to have a reasonable doubt about whatever the missing piece may be. And there are numerous missing pieces in this case. Now, we do not make any excuses. I told you in the opening statement that we're not going to make any excuses for Tom Lane's personality, his impulsivity, his obsessiveness, his stupidity, and his ignorance. Those are all on display. Page 2149. They've been on display throughout this case, and you've heard it. But those things don't mean Tom Lane killed Theresa Lane. Those stupid things he said before during the pendency of his divorce, okay, before Theresa is found killed, all of those stupid things that he said, some of which people say, well, I thought he was joking, I was joking, they don't become important to anybody unless something like this happens. And when it does happen, those people he said these stupid things to go, oh gosh, okay, well, he said them. Some of the people he talked to said them. Now, they want to make an issue of what Tom did and said after he found out sometime around noon on October the 12th when he went to the Basils that Theresa was dead. So he knew that when he had his encounter with the deputy on the side of the road and when he had his encounter with Mitch McRae on the side of the road in handcuffs. And then he goes back to the trailer park and all of these people that they say he is trying to get an alibi out of, what does he tell them? Y'all saw me this morning. You saw me leave to go. I told you I was going to get coffee and donuts and I came, page 2150, I came back. They always look at the husband first. I may need you to tell these people you saw me this morning. Because guess what? Most of them did. They told you they did. A couple of them weren't sure what time he left, except for one lady, and that's the next door neighbor. And what does she say? I was smoking a cigarette out on my porch because I had to be in church at 8:30, and I wanted to smoke a cigarette before I went to church. So sometime between, and it says 8:15, but it's penciled out, sometime between 8:25, and he wrote the word okay, and then he put equals 8:27, because we only live 2 minutes from church, okay? So Tom Lane is at his trailer leaving no earlier than 8:15 and no later than 8:25. And that is important. Now let's back up just little bit. Tom did and said a lot of stupid things when it came to his divorce. He had finally come to the realization that Theresa was not coming back and he started to look for another bride. We don't dispute that. Everybody is different, and I'm not making excuses for Tom, but Tom is Tom. And you can see what kind of person Tom is as far as his relationships go fairly easily. But that doesn't make him a murderer. What is the one thing that Tom did after his, page 2151, after his blow-up with Ronnie Williams during this divorce? He finally comes to the conclusion, the first smart thing he did, the only smart thing he did, that he did up to this point. From the time she moved out, he started doing stupid stuff until October the 6th, a week, 9 days before his hearing on October the 15th in domestic court. And what does he do? He goes and he hires Buzz Jordan to represent him in his divorce. And from that point on, Tom's got nothing to do with the divorce. He gives it to Buzz. The first smart thing he did, reasonable choice. Tom finally makes a reasonable choice. Buzz contacts Ronnie Williams after he's been retained because there's a hearing set in a few days. Now, they want to make a point of saying that Buzz was paid $1,000 by Tom on October the 13th, the day after Theresa's murder. That's the second smart thing Tom did, okay? Because by this time, even Tom knows that he is under a microscope. He's being investigated. They are focusing on him like a laser beam, okay? So what does poor dumb Tom do? He goes and he hires Buzz Jordan with probably the last amount of money he had. He's left with $300 to his page 2152 to his name, and by the time they come pick him up on the afternoon of the 13th, the second smart thing Tom does, he goes and hires a lawyer. And the lawyer is likely the reason Tom doesn't do anything else. But he didn't have time anyway because they come haul him off to jail that afternoon. Now understand, when he's arrested, yeah, he's got gloves, latex gloves in his back pocket, but he's wearing shorts, okay? This is not whatever he may have been wearing on the day. Somewhere in the right it says plumbing drain job. I guess he's saying that he was working on a plumbing drain job. Wearing on the day before. They seize all his clothes. They can and test him, and there's nothing there. Remember what happens after Tom finds out about Theresa's death? Because this is important. It's very important. When he goes back to Tony Basil's house after calling his friend and finding out that Theresa is dead, he goes back to Basil, and it says 30 minutes, but somebody wrote 10 over it. 30 minutes later, if you remember this, when being Vervina Basil, his wife, said when she got there, when he came back, her husband was yelling at Tom. They think you did it. They think you did it. He didn't want to admit, if you remember, he did not want to admit that he asked Tom, did you, page 2153, did you do this? Tom said no. He can remember all this stuff, okay? But he can't remember a denial 12 and a half years later, but he can remember everything else. I had to ask Mitch McCrae, if you remember when he testified, didn't Tony Basil tell y'all that he confronted Tom about killing Theresa and said he didn't do it? Yes, he did. He told you so. He never told anybody anything about that until he gets up here and says, no, it's never happened. So again, when Tom hears this, when Tom is pulled over and detained and questioned, Mirandized, he then makes the conscious decision, I've got to do something. But what does he do before that? What does he do the afternoon of the 12th? Remember this. Tom is the only living relative in this area in Mobile. Yeah, he's going through a divorce, and yeah, he wants it over quickly, but it's his responsibility to take care of Theresa's arrangements. He's just going to leave her at the Department of Forensic Sciences. So what does he do? Page 2154. He goes to the funeral home. After he goes to the funeral home, what does he do? He calls the chaplain about 4 o'clock that afternoon. And yeah, Tom, in his odd, awkward way, he's already a suspect. The chaplain's been out to the scene. He's not out there with blinders on, earplugs on. He knows Tom is a suspect. So certainly he's going to call Mitch McCrae. Hey, he's calling me asking me about insurance. Well, yeah, does he ever say how much insurance? Does he ever say he knows anything about it? No, just that she had it. And he goes to the funeral home, and then he calls the chaplain because he doesn't know. And then in parentheses it says, shocked on how much it can't help bearing her. I can't read his writing. His writing is pretty bad. Okay, the next sentence. Then what does he do? After that, he goes to Walmart and he inquires about it. He leaves Walmart because they tell him to come back the next day. Those are reasonable things for someone to do, even an oddball like Tom Lane. And that's what he did. But by the time he's done all that, it's too late because he's done his dumb statements together with this nasty divorce, all of which is the talk of the 15th Street in Irvington, while all of these 15 or 16, page 2155, 15 or 16 or 17 forensics crime scene investigators, the sheriff, the commanders, the homicide unit, all these people that are out there investigating this accidental drowning are focusing on him like he's the lead dog. And they can try to deflect as much as they can, and they've done it the whole trial to deflect you away from the fact that that was a crime scene from the time they got there. And they can say, oh, well, Dr. Les said could have been an accidental drowning of a 31-year-old, otherwise healthy-looking female with a broken shower curtain laying across her, or it's a homicide. And they want you to think it could have been one or the other. Why? Why do they want you to think that? Because they didn't do the job right when they got there. They want to say that they were understaffed because they didn't have enough people to handle all of the homicides that happened to break out at that particular point in time 12 years ago. But that doesn't matter. That's an excuse, okay? It may have been true, likely was true, they didn't have enough people to cover everything, but this man's life is on trial here today. His life, page 2156, is at stake. They want you to convict him of capital murder and impose the death sentence on this evidence. We know better. This was a crime scene from the jump. I read off a list of names to you. All of these names, all of these people were there sometime before the first deputy on the scene left. And we know he was gone by 2 o'clock because he's out on patrol looking for Tom Lane. So sometime between 10:20 something, when he gets there, Eric Leddick, and 2 o'clock, he has listed 16 different ranking members of the Mobile County Sheriff's Department and at least 2 ranking people of the Department of Forensic Sciences, including the crime scene investigator, whose job it is to document the crime scene. And within a matter of a couple of hours, we've got deputies looking for Tom Lane, and we've got one out at Basil's interviewing them and telling them not to talk to Tom Lane. Don't tell him anything. Don't tell him anything. The crime scene investigation was compromised in several critical ways, and we'll go through those in a minute. Page 2157. Folks, this was, in all respects, a rush to judgment from the very beginning. And now here we are 12.5 years later, and they want you to piece this thing together. They're hoping that you'll piece this together, but it won't fit. Let's go through the important evidence. Melissa, the next door neighbor, Tom leaves 8:15, 8:25. 17 to 19 minutes to get there. This assumes now that he doesn't stop somewhere on the way, okay? But we know there's a witness who saw him, described him, knew him at the Shell station on Range Line and Hamilton Boulevard. They didn't want you to hear that. They want you to hear Mitch McRae get up and say, I looked at this videotape and I didn't see Tom Lane anywhere in this videotape. He wasn't there. And on cross-examination, what does he say? Yeah, he knew the name. I said, yeah, it was somewhere between 8 and 11. 7 and 11. No, I think it was closer to 9. And then he changed what he had to say. His conclusion changed. So you were simply unable to verify with the videotape that Tom Lane was in the store. That's right. They didn't want you to hear that part. Page 2158. So let's assume by their theory that Tom Lane goes to Indy Wilson's house that morning. If he left at 8:15, and then Tom wrote 8:27, 3 minutes, that's going to put him there, and he didn't stop. That's going to put him there. What? 8:35 likely about. It's going to take some time, according to Mr. J, it's going to take some time to park the truck, get out, walk down the driveway, go around the gate, back up the yard, across the yard, onto the porch, and so on and so forth. Now let's talk about, this is a good time to bring this up. Let's talk about this testimony of James J, whose testimony was read here so we know exactly what was said. And if I want to put this in perspective, okay, James J is critical to their case. He's critical because he is the only direct eyewitness to anything that Tom Lane may have done that morning, according to them, all right? He is the guy that sees what he sees, that sees what he says he sees from 37 yards away. I know we've got some football fans on the jury because, well, where we live. But 37 yards, folks, is probably from that wall to the back wall, outside there, okay? What does this man say? Page 2159. The person that he saw was 5 feet 5 inches and 120 pounds. You notice they skipped that part in their PowerPoint? They don't think about that. Why? Because they don't want you to think about that. These were taken out of Tom's house. Mitch McRae, I told you I can tell the difference between a 5 foot 5 inch, 120 pound man and Tom, 275 pound to 300 pound man from 37 yards away. We're not talking about the difference between, say, me and Lee or me and Mitch as far as the description. He couldn't even tell you whether the man was white, black, Asian, or nothing. Now understand, he says He watched him walk up the driveway, through the gate, back up towards the front of the house, across the yard, onto the porch. This is not some fleeting identification here. I will submit to you, folks, that if he's there watching this person doing all this walking, he's giving you an accurate description of what he saw. Because if he's not, then you can't trust that he saw a green truck. F-150, not Ranger. Page 260. They want you to say, oh, well, he had it good enough, but he could tell what the truck looked like, but he couldn't tell the difference between a 5'5", 120-pound man and a 5 10 inches or 11, 275, 300-pound man. Here's where it makes sense. This is what he said. This is an excerpt from James J. sworn testimony years ago about your size. Don't look like no big man to me. He didn't say I couldn't see. I didn't see him. I couldn't tell you anything. All I can tell you what color truck it was, and it was a Ford. It was old. Didn't look like no big man to me. It didn't look like a 285-pound, 300-pound man. Did he? No, not hardly. Is there any doubt? Is there any doubt at all in what James J. describes? None. Again, this description is so far removed from any semblance of Tom Lane that it is huge missing piece of the puzzle. It does not fit. They want you to believe the identification of the truck and ignore the rest of what he said. Why? Because it doesn't fit their game plan. Let's talk page 2161. Let's talk about the crime scene. They tried throughout this trial to minimize the mistakes that were made at the scene. Initially, they wanted to try to blame Dr. C for that. But the facts just show otherwise, and I've already told you about some of those. They want you to believe that the front door of the residence was broken into on the morning of 10/12, and that is the manner in which the intruder got into Indy Wilson's house and killed Theresa Lane. They make no bones about it. They PowerPointed it for you again here today. They want you to believe that. They want you to believe that they just missed it on the 12th. They just missed it because they didn't know what they were dealing with. They didn't know if they were dealing with an accident or a drowning. In spite of the fact we got everybody out there except the sheriff's flotilla investigating this place. It's ludicrous. I'm going to point out the opposite for you, and I think we did that during the course of this trial. Critical witness Iris Rayleigh, Indy Wilson's stepdaughter. Remember Indy? Page 2162. Gets there, as she says, around 10 o'clock, and she calls Iris and tells Iris. Iris says, call 911, I'm on my way. Iris is the first person to get there after Indy. Indy calls 911 at 10 minutes after 10, and she had probably been in the house less than 2 minutes at the time. Keep up with these times, okay? Because they are important. We're going to jump ahead because we want to talk about the evidence of a burglary. What did Iris Rayleigh say about the front door after all these law enforcement people left? And I just have to say, I think Mitch McRae is probably mistaken. Nobody helped them lock this house up, okay? They were left there alone, and they did it themselves. Here's another excerpt from the testimony of Iris Rayleigh. When they were finished and left, then my stepmom, I told her to come home with me, and we went inside, and I went, and she picked up a few things. She didn't get her $3,600 in cash in the envelope or her jewelry. Picked up a few things to take with her, and I locked the front door. Page 2163. Why was it necessary to lock the front door? Because there had been cops coming in and out of it all day. I made sure it was locked, and we left and went to my house. Now, did you actually have to lock it, or did you just check it to make sure it was locked? I had to lock it. So when you left with Indy that day, that door was locked? Yes, it was locked. I checked it several times. Did anyone else go in the house besides you and Indy after the police left? No. And then she talks about going the next day. This is her sworn testimony, uncontradicted sworn testimony. She locked the door. How do we know that the door got broken? The front door got broken sometime after this murder. David Phillips, you remember David Phillips, crime scene investigator? You remember how he came in and said he went there on the 12th? What was his job? He was crime scene investigator. He told you that. What did he do? He told you the procedure is, page 2164, to work from the perimeter in. That's what they're taught to do. And what was he doing? I wrote it down in quotes. Looking for evidence, taking pictures around the perimeter of the house. You saw some of them looking for evidence. He took this picture that day. That's Deputy Leddick working on his report. You see this lady walking over here? Where is she walking? Right where they found the piece of the door at 7 o'clock at night the next day. There's a flash photograph. Notice the proximity of this 10-inch piece of wood with nails sticking out of either end of it by that number 1, where it is in relation to the flowers on the porch. Even better, the flash kind of obscures the stick. The stick is right here. See the bushes and see the edge of the walkway? See the steps coming down? See the door? It's 18 feet from the front door. It's within 4 feet from the sidewalk. It's right where the lady is walking with her arms crossed the day before. They just missed it? I don't believe so. Page 2165. This shows otherwise, but remember this, flip it around. I don't have to prove to you, They have to prove to you beyond reasonable doubt that the door got broken on the 12th, and they can't, not even close. I think this evidence proves beyond a reasonable doubt that it happened on the 13th, although I don't have to prove that. If that door had been busted open on the morning of October the 12th, somebody from the sheriff down to the patrol deputy and everybody in between and the crime scene investigator, somebody would have seen it in broad daylight. They want to say, well, maybe the grass was too high. Come on. You're not going to believe that. Again, they just want you to overlook that. They're hoping that you'll overlook that. That's another huge missing piece in this whole deal. Now, I'm sorry, I just don't put much in this tool mark business. Mr. Milroy, he's a fire debris expert. He's a gun expert. He's a tool mark expert. But he did say he had never examined a, page 2166, chisel before this one 12 and a half years ago. He may have looked at one since. He's not certified in tool mark analysis. The marks on the door are not even near where the jam is, where the door jam is. Look at it. It's 3, and then somebody put 7/8 inches away. He can't tell you. He couldn't tell you whether or not this effort with this tool had anything to do with the opening with opening that door. Have they proven to you that maybe Tom didn't go over there one time before in one of his obsessive compulsive deals and try to go in that house? He couldn't tell you whether or not the mark on that door or marks. He could only identify one. He couldn't tell you when those marks were made, whether they were fresh, whether they were old, when they happened. And folks, that's their burden. They've got to prove that to you. But here's somebody important. He couldn't even tell you whether or not that someone could complete this effort with their bare hands, that they wouldn't need some other type of tool in order to, oh, I don't know about that. Your palm, you're going to force a chisel, page 2167, into a wooden door with your palm. Did James J say, I saw this guy carrying something in his hands? No. What did Lark Huber tell you? Remember Lark Huber, the female detective, now retired? She said, because I wrote it down, that when they got there on October the 13th, the next day, they found the front door had been kicked in. Now let's talk about some other aspects of the crime scene other than the bathtub, which I'll save for last. But before I do, let me jump ahead just a minute because I need to go ahead and get this out of the way. You know, things are bad, are going bad when they trot out a jail snitch. Even 12 and a half years later, they trot out a jail snitch. When you see a guy like him get up here and testify in a case like this, they're throwing something up against the wall and hoping it will stick. The guy started lying right after he told us what his true name was. Everything else he said after that is a total and complete fabrication, except for the facts that he may have been in a cell with Tom at one time. But what did he do? Page 2168. He says he hears all these things. He only could give us 2 or 3 details, all of which are on television. What does he do? He goes to court on November the 6th and he gets sentenced to 99 years with 20 years on top of that. He's not getting out of prison ever unless he gets paroled. Very important point. So what does he do after he gets this life plus purgatory sentence on November the 6th? He immediately begins filing everything he can to get that put aside, get back in court. And what does he do? He writes a letter to his nephew, who just happens to be with Mobile County Sheriff's Department. You need to come talk to me. So the nephew gets Mitch McRae, and they go talk to this guy. And then what happens? He keeps up his efforts to get out of prison. Got to get out, got to get out. For years he tries, and then here, 12 and a half years later, they trot him in here with this story. And what did he tell you? That a year or so ago he came up for parole and he got denied, and that they opposed it, and that he comes up again in page 2169. A year or two, and his hope and his prayer is that they come to his aid and help him get out of prison. They ain't promised him nothing, but that's why he's up here. This guy had somewhere between 18 and 20 felonies dating back 30 years. He used somewhere between 5 and 9 different aliases. He has been a liar and a thief his whole life, culminating when he robbed someone. A robbery is not a theft. A robbery is using force to get your property or to get your money. He is absolutely, without a doubt, completely unworthy of belief. You should expect more credible evidence than to have to listen to that slug. Now let's go back to where he should be. Back to this crime scene. But now let's go back to where we should be. Back to the crime scene. And here's another huge piece of this puzzle that just doesn't fit at all. They went through that house. Granted, they didn't do all of it on the 12th, or much for that matter. They check all of Tom's clothes. One thing they did do on the 12th is the Department of Forensic Sciences, which is their protocol. Okay, it's what they do every time. It means these are the procedures that we follow. They measure the water level in the bathtub. They remove Theresa from the bathtub. They bag her hands. Now they want to minimize bagging hands. Oh, we may find something, we may not, but they bag those hands for a reason. And the reason is that if a person is defending themselves, okay, and they're using their hands, and they can get blood and tissue under their nails or in their cuticles, trace evidence. And so they bag the hands. They go through the house, they get Theresa's clothes, they execute search warrants on Tom's truck and on his house, and they get these clothes. They get blood off of the comforter. So they're looking for physical evidence at these scenes. And what does Mitch McRae say under oath on October the 15th, 2003? This is evidence that during the act of the murder, blood was transferred to the bathroom walls and bathtub, and most likely to the offender or the offender's clothes and or the offender's clothing. Huge missing piece of the puzzle, because there is absolutely nothing, not one single thing in that crime scene to connect Tom Lane to this murder. Okay, I'm going to stop on the top of page 2171. 2171, I'm going to pause and we'll pick up in a little bit. All right, let's pick up with page 2171. Okay, huge missing piece of the puzzle, because there is absolutely nothing, not one single thing in that crime scene to connect Tom Lane to this murder. There's no blood, there's no DNA, there's no fingerprints, there's nothing. Another doubt, another missing piece. If you remember too, there was some discussion, and I had to make them admit this, that there was some keys missing from Indy's house, Theresa's keys. Part of the reason why they, in this search warrant, they set out that keys were taken likely by the offender. There's no keys found connecting Tom Lane to any of this. And we're jumping a little ahead here, but they find no jewelry. And this jewelry is worth thousands of dollars. You heard the description. We're not talking about costume jewelry here. This is worth thousands, and $3,600 in cash in an envelope. They go all through everything Tom's got. There's no jewelry and there is no money other than some loose change, and that's it. They want to make you believe that Tom took these things, and yet there's no sign of them. If Tom used money stole out of that house to pay his lawyer the next day and had $300 left over, that's $1,300. Where's the rest of it? Where's page 2172? Where's the rest of it? Did they ever find the rest of it? No. Did any witness ever come? Tom Lane came and stashed his money with me? No. Did they ever find any jewelry at a pawn shop and Tom's picture up on the surveillance camera? No. We'll come back to that. The $3,600 and the missing jewelry, where do we start? 4 days? 4 days. Tom writes in pencil, none of Theresa is missing. I don't know what he means by that. The $3,600 and the missing jewelry, where do we start? 4 days, 4 days. And I'm sorry. I understand Indy Wilson was upset on the 12th and only maybe took a few things with her when she went to Iris's house. But this is her roommate we're talking about, okay? And I'm not attempting to minimize it, but this is your roommate of a few weeks, maybe a month or so. It's not your daughter, it's not your mother, it's not your husband. This is your roommate. And I can tell you it is conceivable that a woman in her late 50s who babysits for $30 a week and has thousands of dollars worth of jewelry and a $3,600 in cash is going to go off and leave that there for 4 days. It doesn't happen. It makes no sense. Particularly when she testifies, and Iris testified, they went back to the house every day to get some more things out of the house. And for 4 days, you're going to get this dress. Page 21773. And you're going to get this toothbrush, and you're going to get, oh, I need to get this piece of luggage. And oh yeah, I forgot my $3,600 in life savings and all my jewelry. And the two most value things that this woman has in that little house, it does not pass the smell test. It fails it in every respect. You notice they don't talk about that in their PowerPoint either. Tom is in jail before sundown on the 13th. They had days, weeks, months to investigate this alleged missing jewelry and this missing money, and maybe they should have let somebody know, you know, well, maybe this just doesn't add up. Maybe we're wrong about the break-in of this house. There's that big stick with the nails in it. I'm surprised somebody didn't get it in their foot. Something about this don't make sense, y'all. We need to look at this. No, focus on Tom. Did anybody ever go through any of this luggage? Did anybody ever question anybody else's associates on the other side of the fence? Did anybody ever question anybody in the Filipino community? Did Indy Wilson have any enemies? Did anybody else know that she, page 2174, carried $3,600 in cash and thousands of dollars worth of jewelry in a house? Then in pencil, Tom writes, did Indy Wilson have a friend that owned a green truck? Worth of jewelry in a house? No, they didn't do anything except focus on Tom because of his own stupid mouth. They just want you to overlook that too. Let's talk about the life insurance. When Judge Graddick reads you the indictment, and this was in the PowerPoint, they have to prove to you beyond a reasonable doubt that when Tom Lane killed Theresa Lane, that he did it for the insurance money, okay? That means they've got to prove to you beyond a reasonable doubt that Tom went into that house to kill her because he wanted to get the insurance money. And then in pencil, Tom writes, I was not the beneficiary. See, June 21st, 2003, benefit from not, but this lost it. I guess Tom's trying to say he was not the beneficiary. Is there any evidence of that? None. Zero. Zip. Doesn't exist. They want to make a big deal out of the fact that he had overdrawn his checking account at Compass a couple of times. You heard that lady testify. There's no evidence at all he even knew he was overdrawn when it happened. He deposited probably $6,000 to $8,000 was run through that account in 90 days that he had it. He opened it up when Theresa left him. Page 2175. Did they ever check to see if he ever had any other checking accounts? Did they check to see if maybe he had gotten a cash advance no one had on one of the credit cards that was in his wallet? No, they did nothing. They plugged that in here. They plugged that in here to try to show you that Tom did this and it doesn't work. What does Tom do? They want you to think that he killed her in order to get the life insurance. Like I said, that's something that's got to come before the murder, not after. And I told you he's the only relative that Theresa had here. He finds out about her death, and in his own odd, stupid way, he sets out to try to do what he thinks he's supposed to do. At some point in time, he realizes that he's a suspect here. But by that time, everybody else knows it, and the light bulb goes off in Tom's head. But what does he do? He goes to the funeral home. He calls the chaplain. He calls the chaplain first, talks about how he goes about getting a death certificate. He knows he's going to have to make arrangements. He asks about life, page 2176. insurance because he's got to get the death certificate. And he goes by Walmart and he's told to come back. That's it. And he goes back the next day and he finds out that she's changed the beneficiary and he leaves. Okay, the lawyer says he finds out that she's changed the beneficiary, but Tom writes that he knew it. He already knew it. That's it. That is it. There is no other evidence. There is no evidence whatsoever that before this murder, Tom Lane even knew how much life insurance she even had. None. Go through your notes. I challenge anybody to find me some reference that Tom Lane knew how much life insurance Theresa may have had. And I'm not talking about some true detective thing that 12 and a half years later that Tony Basil comes up in here and makes up, because nobody ever heard that before, and he had been interviewed numerous times. That's just a pure fabrication because he's been trying to put Tom away since day one. Basil, his hostility was open. To say that Tom, when he killed her, did it for money, for insurance, would require pure speculation on your part, and as the judge will tell you in this charge to you, your verdict cannot be based on speculation. Your verdict has to be based on fact and your analysis of facts. Page 2177. Facts sufficient to cause you to believe the truth of the matter asserted beyond a reasonable doubt. Speculation is guessing, and we don't guess in a capital murder death penalty cases. We do not guess. They never check to see what other sources of money that Tom may have had. A lot of people have a little rainy day fund for hurricanes and that kind of thing. Maybe Tom had one. Tom crossed out the word maybe. Did they ever check that? Did they ever check any of the other banks? Did they ever contact any of the credit card companies to see if he got a cash advance? No. Oh, here we go. He got overdrawn on a couple of days before this, so there it is. It's his motive. He had to have money. The love of money is their initial thing. It doesn't fly. Now again, there is another huge missing piece of this puzzle. Let's talk about the bathtub. And this is a timeline, and it's critical timeline. And I hope that you kept up with all of these things when they were pointing them out to you, because there's a method to this, and I hope that you followed it. Okay, I'm going to make a point here. Other bank accounts, and if Tom calls me back, I'm going to say, how come other bank accounts, his lawyer did not introduce that? Did your lawyer introduce, I'm writing this out, give me just a second, introduce other bank accounts? Question mark. Okay. Okay, I hope that you followed it. Page 2178. 19 minutes, 17 to 19 minutes to drive from DIP to 15th Street to Irvington. If Tom leaves at 8:15, but Tom has marked and changed that to 8:30, again, that's going to put him there about 8:45, approximately getting out, walking up, He's home by 9:30 according to Melissa, who had just come home from church, and Tom's truck is parked in the driveway and he's not seen, so he's inside, so 9:30. When Indy Wilson walks in the unlocked back door, what does she say? She could hear from the kitchen as soon as she comes in. If you remember, the back door goes straight into the kitchen, water running, quote, hard and fast, closing quotes, and the tub was full, but it was not overflowing. It was not overflowing, and she turns off the water. Now, what time is it? What time is this? This is a couple of minutes before she calls 911 and calls Iris Rayleigh. So what? 10:05 is what we're talking about, probably. I've done the math. It's about 51 to 54 minutes that the water is running in that bathtub, hard and fast. Why? Because Tom Lane would have had to have left there somewhere around 9:11 and 9:13. Page 2179. In order to be home, in order for the Brunos to see him in his driveway. Again, this assumes that he doesn't stop at the Shell station and get seen by this woman and identified by photograph on the way back. Iris Rayleigh arrives at 10:25 by her estimation. Theresa is completely submerged in the water. The water level is above the overflow drain, and she hears nothing except her heartbeat. She doesn't hear any water dripping, trickling, draining, flowing, nothing. Again, another excerpt from Iris Rayleigh's sworn testimony years ago. Ma'am, in response to Miss Rich's question, did you say that nobody was there? It was just quiet, yes or no? Yes, no one was in the house. Me by myself to check the water for 911. It was quiet except for my heart beating. So when you checked the water, everything was quiet? Yes. Not maybe, could have been, I don't remember. Yes, quiet. And the water is above the overflow. The court. We need to take a break, Art. If, page 2180, if this is a good time. Miss Powell, that would be good, Judge. Mr. Powell, that would be good, Judge. I'd like that. Thank you. The court. All right, let's take a 10-minute break. Brief recess. Jury present. The court, please be seated. All right, you may resume. Mr. Powell, thank you. Pardon me if I repeat myself here initially. We talked about Iris Rayleigh getting there and the water being above the overflow valve when she's completely submerged in the bathtub, and that she hears nothing except her own heart beating. Now, this is an hour and 20 minutes approximately after Tom Lane would have had to left there. Okay, over an hour, and the water is still above the overflow valve and nobody hears any drainage at all. Deputy Leddick gets there 8 minutes later at 10:33. He's the first response. He testified that the water was 3/4 of the way up the overflow, which means 3/4 of the way up this circle, which would be right about here. And page 2181. He testified that when he went into the bathroom, he could hear the water trickling into the overflow. Trickling. And that the drain was closed and the bath drain was up. And it's closed. And I would submit to you, first of all, here is the photograph that illustrates what the bathtub looks like after it's been drained. This is how Theresa was found. And remember, please, what Lark Huber testified to, because she gets there shortly thereafter, and she says Theresa's hair is in the drain. Do we need her to tell us that? It helps. But look at the picture. Now, they want to make an issue and say that, oh, well, the tub didn't overflow, so it must have been working properly. Again, they don't want you to think about that. They're hoping that you won't think about that. But I can promise you, if there's more water pressure going into the overflow valve, if there's more water pressure going into that overflow valve because there's more water in that tub, like Indy Wilson said, when it's almost full up to here, he wants you to think, because he spent 2 years as a pipe fitter, that this thing would still be working properly. And page 2182, it would be pulling more in because there's more water pressure. But what else is going to get pulled in there more so than is being pulled in there when this photograph is taken? Her hair. Shane Stranger gets there 23 minutes later at 10:56. He testified that the water was above her face and over the overflow valve. Now, folks, you've got to figure it's going to take him a couple of minutes to get inside if he arrives at 10:56 according to the event chronology. So let's say roughly at 11 o'clock, and he doesn't say he hears anything. He never said a word about whether he heard anything. We're talking about almost 2 hours after Tom Lane, if he had done this, would have gone from Irvington. It doesn't add up. David Phillips measures the tub at 7 inches of water. The time is kind of unclear because he's already been doing his crime scene investigation from outside in, but it's close in time to the time that Shane Stringer got there. Lark Huber testified that the water was just below her mouth sometime after 11:09, which is when she got there. Now, we are talking about 2 hours later. Page 2183. And that the water was dripping into the drain, dripping. And as to reiterate again from the photograph I showed you a minute ago, her hair was in the drain. She's not the lead investigator in this case. She's working under the supervision of the lead detective, Mitch McRae. So you can assume she told him that. This is what they would have you believe is capable. One on each side, that this area in here until it meets here and joins the bathtub and then comes back up on this side in the same fashion, but with hair in it, is going to keep this bathtub from overflowing for 51 to 53 minutes of water running hard and fast. And then Tom writes in pencil, photos have her hair in over the drain. It is so much in drain holding hair in I can't read the word, in air, I don't know. You don't have to be a plumber, you don't have to be a mechanical engineer, you don't have to be a tub expert to know if there's more water going into that bathtub than there is draining out. It is going to overflow, and it's not going to take 51 minutes to do so. And think about this now. There's no signs in that house of any forced entry at all when they get there. Nothing is in disarray. There's no signs of a struggle, so we can probably infer, page 2184, and the judge will tell you that you're allowed to make reasonable inferences from the evidence. It's reasonable to infer that when the intruder went into Indy Wilson's house and discovered Theresa, she was already in the bathtub. And then Tom writes in pencil beside that, wrong. Fight starts in the bedroom. That is where the blood is at. So when the lawyer says that she was already in the bathtub when the intruder entered, Tom doesn't agree with that because there was blood in the bedroom. He said that's where the blood is at, so that's where the fight started. With her water drawn either about to take a bath or taken a bath when this occurred. So what does that tell us? That she had enough water in the bathtub when she started her bath, which would have been before anybody came in. So it's not like there's got to be a full bathtub of water for which the intruder is responsible for. The intruder is only going to be responsible for whatever happened after the drowning, which I would submit to you is not that much water. If you put a 130-pound woman in a small bathtub, it's not going to take a whole lot of water before it's up to and in the area of that overflow. And I submit to you that that's what the overflow is for. The overflow is to handle any excess water when you draw your bath and you get in it, and that it doesn't rise up and go over the side, that it will drain slowly. It's not designed to handle, and page 2185, unknown total volume of water coming in for 50 minutes without overflowing. Look at it. Look at these little areas on the side. It makes no sense. Elementary school physics tells us that it's just not possible. It's not. They have to prove, folks, not only that it was possible, which they haven't done, they not only have to prove that it was probable, but they haven't done. They have to prove it happened the way they say it happened beyond a reasonable doubt. How do you do that? How do you do that if you're in their shoes? What do? You take the thing apart and you look at it. You talk to somebody. You talk to somebody that knows how things work, how these things work. You go out and find somebody to come in here and say, oh yeah, this is the way it's supposed to work, and sure that they didn't do anything. They didn't even look at the thing. They assumed that it was working properly in spite of the evidence that's slapping them in the face. If they just step back, back up and look at these things objectively and critically. Because you're going to charge somebody with capital murder, you better be able to, page 2186, prove that he actually committed the murder and not just said a bunch of dumb stuff to show that he had a motive. Because the judge is going to tell you that's all that is. That's all that it is. That's all that is. All this talk before this lady was drowned simply goes to show motive. They want to make you think it shows intent. It doesn't show intent. The law says it shows motive and nothing more. They cannot prove the physicality of this crime. They cannot prove that Tom Lane could have done it. It was possible for him to do it, probable for him to do it, or that he did it. And the last one is the only one that's important because they never check it. Again, let's flip it. Who has to prove this? Who has to prove that this timeline supports a reasonable hypothesis that Tom Lane killed Theresa Lane? They do. And they, again, have failed. But they want you to think about that. But they don't want you to think about that. They're hoping that you're not going to think about that. We're talking anywhere from 51 minutes on the inside. That's the minimum amount of time. And I can tell you that if Tom Lane had done this and left at 9:11 that morning in order to be home by 9:30, if he had done this, that, page 2187, that water would have been all over this house. There's no way that this timeline fits with anybody's theory that Tom Lane did this. And they have to prove to you that he could have done it and did it, and they can't do it. This speaks for itself. Common sense tells us. Remember, I asked him, made a joke about the fact that his hair wouldn't stop up a drain, and we all laughed. But to Asian women with long hair in an old house and a small bathtub, I can promise you that And then the word is will, but Tom wrote was, clog up that drain. See photo and evidence, Tom Lane wrote. What did Melody Little come in here and tell you, that very last witness that testified? She bought this house from Mindy Wilson right after this happened. And she said from the time that she moved in, that drain was slow. And I can promise you, this is, everybody knows this, the drain on the top, that the overflow drain is connected to the main drain. So if the main drain is slow, the overflow is going to be slow. But it's going to be real slow if it's full of hair. After they locked in on Tom Lane in the early afternoon hours of October it says 12th, but Tom Lane wrote 13th. Nobody thought another thing about that bathtub. And then after they find the stick in the yard the next day, then they have to try to back that into their theory that this was somehow a burglary, and it does not fit. I tried to point out to you all of the critical missing pieces of the puzzle, and each of those critical missing pieces represent reasonable doubt. That's clear. And that's all that we have to do, and we don't even have to do that. You can find a reasonable doubt if we just stood up here and did nothing. But we've shown you this. We've shown you these things from their own evidence and from their lack of evidence and the lack of things that they should have done and didn't do. But the critical thing is that the final piece of the puzzle, the piece that would show that Tom Lane could have likely did and in fact did kill Theresa Lane, and they simply cannot do it. So they want you to concentrate on all the bad stuff that Tom said. And Tom's a heel, okay? There are other words, but he is a heel. He's not a nice guy. But we don't send people to death row for not being a nice guy or for going through a bad, page 2189, or going through a bad divorce, or for being a misogynist, a sexist, somebody that women need to stay away from if they're thinking about getting in a meaningful relationship. Stay away from Tom. But there's no evidence whatsoever that Tom Lane killed Theresa Lane. I have shown you through the course of this trial the likely impossibility that Tom Lane could have done it. He didn't have to. All I had to do was point it out for you because you understand what the burden is. The judge is going to tell you again. Let's talk about the indictment, and then I'm going to wrap this up. The indictment charges in count 1 that Tom Lane intentionally killed Theresa Lane during the course of a burglary, that he entered and remained unlawfully in order to kill her. We believe the evidence is clear there is no burglary, at least not on the morning of October the 12th. And if you believe that they failed to prove that this killing was done during the course of a burglary, you can then consider whether or not it was done without evidence of a burglary. We don't believe they've shown any of that, but if you find that that didn't prove a burglary, but they proved a murder, page 2190, then you could find Tom guilty of murder. We don't think they've even proven anything except motive. Count 2, same thing, but I submit to you, count 2 is easy. There is no evidence whatsoever other than Tom checking with Walmart about insurance, along with the same time he asked the chaplain about it, death certificates and paperwork, and he goes to the funeral home. And from that, they want you to find beyond a reasonable doubt that when Tom Lane killed Theresa Lane, assuming that you find that he did it for the insurance money, and that just simply does not exist. And then finally, and what we're asking you to do after you've considered the 2 capital counts of indictment, count 1 and count 2, and you've considered whether or not the proof of the underlying felony burglary on the one hand, insurance money on the other, if you find those don't exist, then you're left with murder. We submit to you they haven't proven a murder. They haven't proven anything close to a murder. And if you find that to be the case based on the evidence and by following your oath as page 2191, jurors, you will find that Tom Lane not guilty. And that's what we're asking you to do here today. Thank you very much. Miss Rich, you know the defense got up and they said in opening we focused on the defendant like a laser beam, and talked again today that we focused completely on the defendant. Well, you know, ladies and gentlemen of the jury, that's just not what happened. If you think about how this case unfolded, okay, and you think about everything that we've shown you, the most important thing is Theresa Lane. Theresa Lane, the victim in this case, she didn't have any enemies. She didn't have people that didn't like her. You heard testimony from the Filipino community. He said we didn't talk about go and talk to anybody in the Filipino community. Oh yes, we did. We brought you all of her girlfriends, and then Tom writes only 2, from the Filipino community. And Theresa Lane just didn't have any enemies. The only enemy Theresa Lane had was the defendant, Tom Lane. Then Tom writes, they did not testify to me being an enemy. Theresa was a hard-working young lady, full-time at Walmart. Employees of Walmart said they would love to have 100 more of her. And then Tom writes, because she is submissive. And then Miss Rich goes on to say, and they want you to say, well, wait a minute, we focused on Tom Lane. No. Day one, if you remember the police absolutely did not know if this was an accidental drowning or homicidal drowning. And if you listen to the testimony of Dr. C, that's exactly what he said when they left that scene. They didn't know. And if we had focused on Tom Lane like a laser beam, like they want you to think, then when Mitch McRae questioned him on the day of the murder, we would have arrested him and put him behind bars. But that's not what we did. We let him go. We let him go, and we let the evidence take us. We let the evidence take us in this investigation. That's what happened. We had not talked to the neighbor at the trailer park. We had not talked to the neighbors at Iris Rayleigh's house. We had not talked to the chaplain. We did not know that he was trying to collect on his life insurance. None of those things were known, and he was let go. And as this evidence unfolded, if you remember on the 12th, real important, after Dr. C said he wasn't sure if it was an accidental drowning or a homicidal drowning, you know, they want to make light of the fact, page 2193, they want to make light of the fact that Indy Wilson was hysterical that day. There's nothing to make light of. There's nothing to make light of that. She was hysterical. This was her friend, and they wanted to call Indy Wilson her roommate. She was just a roommate. Why would she be so upset about that? She was just a roommate? She wasn't just a roommate. Indy Wilson said that they had been good friends for 2 years. 2 years. This is not just some flippant roommate. This is her friend, and yes, she is hysterical. She comes home thinking she's coming home to her roommate and her friend, Theresa Lane, and there's her friend dead in the bathtub. Tom writes, she is afraid of being arrested for killing Theresa. She is hysterical, and they can't make hide nor tails of. She's saying things. She's saying Tom. She's saying all those kinds of things, but she's hysterical. And it's not until the next day that they get a statement from her and they're able to calmly sit down with her. She's still very upset. She's still very, very upset, but they get a statement from her. And on the 13th, it's not until the morning on the 13th, which is the day after the homicide, if you recall, when Detective McRae says he goes to the autopsy scene, and it's clear because there's, page 214, been a day, just like Dr. C said, for the bruises to manifest. And they've drained the blood from her body, and they see the bruises, and then they see the defensive wounds. And that's really important because they didn't see that at the scene, okay? And at that point at the scene, if you recall, David Phillips, the only evidence they took in the beginning was the victim's clothes. They didn't search that as a crime scene. And then Tom puts in pencil, lie. Phillips said he did something, tried to get prints off tub. They didn't collect the evidence on the 12th. They didn't because they didn't know. They didn't know. It wasn't until they went back on the 13th, after they had talked to the neighbors, after they had talked to Indy Wilson, after they had found out from the autopsy that it was a homicide, and after they did the neighboring canvass of the trailer park, and the victim talked to her other friend, Nadine Hildesheim, and the other Asian ladies in the community. It wasn't until then that they considered this a homicide. So at that point, they went back to that scene, and they took a lot of evidence from that scene. Because at that point, it was a murder. It was a homicide. And after they interviewed all these people, page 2195, and after they found and questioned the defendant, but when they found the defendant was seeking an alibi, that the defendant had gone to Walmart to try and collect the life insurance, that Theresa's only enemy in the world was Tom Lane, and found information about their horrible divorce that they were going through, it was only after all that evidence was collected that Tom Lane became the suspect. There's no question that the victim was scared of the defendant. Pamela Hallbrook, her co-worker, said that they would take various routes to and from work. She and Theresa would take various routes to and from work because they didn't want the defendant to follow them. And then Tom wrote, not true. Iris Rayleigh testified that 2, and then Tom Lane put 4 weeks prior to this, the defendant came to their home. So that's proof that he knew exactly where Theresa was living. Theresa was scared and they wouldn't let him in, and the very night they went and spent the night somewhere else. Lily Beth Smith, who Indy babysat for, knew Theresa was scared of the defendant, and she was, in fact, the house that they went to stay on the night that Tom Lane had come to their house. Page 2196. Renetta Cross, the manager at Walmart, the overnight manager at Walmart, said they had a plan in place. And when Tom Lane came into the store, their job was to get Theresa to the back because she didn't want to have anything to do with Tom Lane. Tom wrote in pencil, "Not true. She was getting money from me." Nadine Hildesheim she absolutely said they were scared of Tom, and she was the one that helped Theresa to get to the divorce attorney to get the divorce to get away from Tom. And she saw choke marks on Theresa the day that Theresa moved out of the house from the defendant, Tom Lane. And Debbie Gable Insurance at Walmart, she said, "I would like to have 100 more of her." Jerlene Gilmore, Walmart, Tom said she heard the voice message on Theresa's phone. "If you don't come back, you'll be sorry. You'll be sorry." And then Tom wrote, "Not according to Theresa phone records." Now, you know, when the defense got up here and did their closing arguments, they said the store clerk at the Chevron, that day, the store clerk at the Chevron, well, they could have brought you the store clerk at the Chevron. They didn't want to bring the store clerk from the Chevron, page 297. Mr. Powell, I'm going to object to that. That's improper. The court sustained. Miss Rich, the evidence is very clear about the store clerk. The evidence is very clear about the store clerk from what you heard on that stand. And Mitch McRae said that he looked at the tape from 7 till 12, and not one time was the defendant Tom Lane in that Chevron. Not one time. That is not an alibi. He wasn't at the Chevron, ladies and gentlemen of the jury. We know where he was. You know where he was. You know what? I've got to write a question down, otherwise I'll forget it. Why didn't Chevron clerk testify? Okay. He was traveling to the home where Theresa Lane was staying, and he murdered Theresa Lane. The videotape does not lie. And then Tom wrote, "What tape? None of Chevron." The defense, so I'm going to write down also, was there a tape? Was there a tape? Okay. The defense made some comment about no one identified the defendant. The defense made some comment about no one identified the defendant in a photograph as being in that store. I don't know what that's about, because the videotape, and then Tom puts in parentheses, "not from Chevron, yes, from Texaco." The videotape is the evidence in this case, and the videotape clearly shows, according to Detective McRae, that the defendant was never in that store. And Tom wrote, "True, I was not in Texaco/Shell. I was at Chevron 2 times." Okay, and he knows he's not in that store. The defendant knows he's not in that store, and that's page 2198. Why he goes to everybody at the trailer park and tries to get somebody to alibi him. But it was very consistent that everybody in the trailer park said, "We're not going to lie for you. We're not going to lie for you." Tom wrote in the parentheses, "since Theresa's friends." Okay, now, continuing, now they talk about the snitch. They talk about the person we brought in from jail, and they say that it was 12.5 years later, and he comes to the state and tells the state that he told us what he told us. That's not the case, ladies and gentlemen of the jury. And Tom writes in pencil, "And we were cellmates." Not true. And his uncle, and he is an ex-gang member and is a sheriff. His uncle is a sheriff, and he is an ex-gang member, and the gang wants to kill him, so he is ill in PC. I don't know what that stands for. If you listen to the testimony, he told us what he knew about the case, and he told us that the defendant confessed to him that he had killed Theresa Lane back in 2003. He didn't come forward now in 2016 and tell us that. He told us that back in 2003. Then Tom writes in the pencil, "The state felt he was unreliable in 2003. That is why they did not use him." The defense quote said, expect more credible evidence than to listen to that slug. That was his words. You know, Dewitt may not like him. You may not like anything about him. He's a career criminal, there's no doubt. And we didn't try to hide that at all. We brought that information out on the stand, page 2199. And you know what? They called him a slug. You can call him a slug. You can call him a thug, absolutely. But he's just icing on the cake. He is just icing on the cake. We have proven to you capital murder in the case even without Randall Wayne Dewitt. Mr. Dewitt taking the stand. They talk trace evidence and they talk about no evidence being under the fingernails. But do you recall Bill Jones, who got up there and said when somebody is in water, we've never found trace evidence? Never in his entire career. And that's exactly what happened in this case. They didn't find trace evidence because she'd been in the water. She had been in the water. But there was no doubt, ladies and gentlemen of the jury, that Tom Lane at 12 o'clock on the day of the murder had fresh scratches on his legs. Fresh scratches on his legs. And then Tom wrote black and blue marks. Oh, Tom wrote no black and blue marks. You know, again, they want to say that Indy Wilson is somehow just a horrible person because it took her 3 days to realize that she had money and jewelry missing from that house. But think about it. This was her friend. She never spent another night in that house. She never once could stay in that house again. It was her house. Page 2200. She owned it. She owned it. Yet she couldn't go back in there and she couldn't stay there. And they want to say, well, wait a minute, there wasn't any money or jewelry found on the defendant Tom Lane's house when it was searched. Now, his house was searched on Wednesday, okay? He had already been questioned by the police and released. He's not going to leave the money and jewelry that he stole during the murder in his house. That's just not going to happen. That's absolutely not going to happen. And they want to make this big deal out of why does Indy Wilson leave? Why does Indy Wilson have $3,600? She only makes $30 babysitting. Tom Lane wrote in pencil 3 years salary. But remember her testimony? She's retired from Social Security office in Illinois. She worked there full time and retired out of that office. She had a wonderful husband. She's a widow. She owned her house outright. They want to say Indy never had any money. That's absolutely not true. In fact, the evidence that was presented to you is absolutely the contrary. And I submit to you, she wasn't thinking about herself. She was thinking about the fact that her friend, someone she loved, had been, page 2201, brutally murdered in her home. And James J., you know, they brought up some testimony about James J., and I think it's important that you remember that James J.'s testimony was that he was very clear about the truck. He said it was, he even knew the years of the truck. He said it was somewhere between a 75 and 78 older model Ford, and it was pea green in color, okay? Now, he was sure about that. Now, when he was asked to describe the person that he saw get out of it, he was pretty clear about that too. He said, so the question was, so you really couldn't tell anything about him? And he said, no, I really couldn't tell. And in fact, when I questioned Mitch McRae, why didn't you show him a photo spread? He said it wouldn't have done any good. He was clear. He did not and could not testify or describe the person that was leaving. Then that he saw going up to that house. Now, pea green Ford pickup truck, he knew that. He was a mechanic. He knew the years. He was sure about that. And that's exactly what the defendant, Tom Lane, drove. A very distinct, very old antique truck, pea green in color. And Iris Rayleigh, they wanted to make a big deal about Iris Rayleigh and the fact that she locked the front door, and she absolutely said that she did lock the front door. But nowhere in her statement did she say she checked the chain. She didn't. She didn't check the chain, okay? She says, it was a deadbolt lock first, and then a regular just doorknob, you know. And the deadbolt didn't have a key and the little knob. We turned it, and it had a lock, and you would turn it up. And that's what she did to lock the door. Absolutely undisputed, that's what she did to lock the door. She never once saw the chain until the next day. She never once saw the chain until the next day. Now the defense wants to make a big deal out of the timing, and the timing is critical here. Timing is very important. And we've proven to you that when Scott and Melissa Bruno got out of church, they were going to church, it was about 5 minutes before 8:30, about 8:25 if you recall. Page 2203. The church was 5 minutes away. Her husband was still getting dressed. She was out on the porch smoking a cigarette. And they came home from church a little after 9:30. Church was over at 9:30, and they drove straight home. And then his screensaver was changed at 9:45. So the defendant had an hour to an hour and 10 to 15 minutes to commit this crime. And Tom writes in pencil, corrected time 10:23 after adding 38 minutes. Okay, that's interesting. He leaves. He leaves his house. They see him leaving his house in his truck. Very unusual. Very unusual. And it's in the small details. Very unusual that he always took his dog everywhere with him. But on this particular day, very unusual that he didn't take his dog. And he travels to the victim's house. You can't have a dog in the car barking, raising hell while he's breaking in to kill his wife. And he knows where she lives. We've proven that because 2 weeks prior to that, he was there. And he tells Paula Lapointe, I found out where she lives. I know where she lives. I don't need your help anymore. You remember that? He wanted her help to try to find her. And Mr. J says it's around 8:30 when he sees the truck parked out front. And Mr. J says, page 2204, I see the, and then Lane writes in pencil, 120 pound, I see the person that gets out of the truck. I can't really describe him, but I see the person that gets out of the truck. And then Lane writes the F-150 truck, but the transcript just says the truck. The truck is parked here. He walks down the driveway. He walks into the gate. Why? Why is somebody going to do that? Why did Tom Lane do that? He did because he wanted to make sure that there was nobody else in that house. He knew he had already taken Theresa's car and turned it into the dealership. Then Tom wrote, Mr. J sets red cane that bluing there was also there, so Indy Wilson was home. Oh, Mr. J says red car, I don't know, that belonged there was also there, so Indy Wilson was home. Oh, so I guess what Thomas Lane is saying is that Indy Wilson was home when Theresa was murdered. Interesting. Okay, and he wanted to make sure nobody else was in that house. And when he walks into the front and he walks up to the front porch and he can't see him anymore, why can't he see him anymore? Remember, the big bush is obstructing his view and he doesn't know what happens after that. After the defendant, then Tom writes in pencil, Jay says she was home. After the defendant made sure Indy is not home and there's nobody else, he goes up to the front door. The bushes are hiding him. And what does he have? What does he have? He has the chisel. He has the chisel, I submit to you. He could have had more than just a chisel, and he has got to get into that house. He's got to get in that house, and he breaks into that house. Now, I want to tell you, really important, page 2205. When you heard the elements of this crime, and when the judge is going to instruct you on the elements of the crime, a lot of people think when the state has to prove a burglary, we have to prove breaking and entering. A lot of people hear breaking and entering, but nowhere do we have to prove breaking, okay? We don't have to prove anything is broken to get into that house. Someone can go into a house where they're not lawfully welcome and commit a burglary, okay? An example would be you leave your back door open because you trust people in your neighborhood. I don't recommend that these days. But if you did that and someone entered your door and crossed over your threshold, but they were not welcome in your house and they stole a bunch of stuff, this is a burglary. That is knowingly entering or unlawfully remaining in a dwelling, and that is a burglary. So we don't have to prove at all any breaking, but I submit to you we did, and we proved it 100%. If you recall, Scott Milroy said there's no other chisel in the world that could make those marks. No other chisel in the world that could make those marks? page 2206. And when you look at the evidence, ladies and gentlemen of the jury, here's the door, here's the screen door, okay? And there's a hole that goes right here and right here that fits right where the screw is, okay? And look at this. This was taken off. This piece of wood was taken off by the people who removed that door. The piece of wood is the piece of wood that was found in the yard, okay? But if you put the two together, there's these holes right here and here. Not the holes that put it in the door, but there's these holes right here and right here. And if you put that in there and you squeeze it into the hole, the nails match perfectly and these pieces of wood go together. And you take the screw that's sticking out right here and you put it exactly where Scott Milroy said it went, and it goes perfectly right there. Then Tom writes 5 to 6 inches below where you have to get to the doorknob latch. So when the defendant walked up on this porch, I submit to you, ladies and gentlemen of the jury, that he pried the piece of wood off, and that's how he got it in the front yard. And then Tom wrote the day after. Now this piece, if you remember, is still attached right here, and there's a metal strip that, page 2207, goes right here. You saw the photographs. Now that's real important, is when that is put here and this piece is put here, okay, you notice the chisel marks are down here, okay? The chisel marks are down here because after the defendant was able to get this piece off and this piece was still on, he couldn't get the chisel underneath here to try and break the door threshold. So he had to move down here to where these 3 marks are. And he went under the board, just like Scott Milroy told you, with the chisel, and that's what made these marks here. And there is no doubt, 100%, the chisel found in the defendant's truck is a chisel that made these marks on this door. And when he got in that house, Theresa had gotten home, and she had started her bath, and he drowned her in the bathtub. He drowned her in the bathtub. She fought viciously. She fought brutally, and he drowned her. You know, I got to make a note here. Tom Lane's take on chisel marks. I want to hear his side of the story about how come the chisel is apparently matches that was in his truck. Okay, and what also is very important is there was nothing ransacked in that house. Everything was neat and tidy and in order. There was nothing ransacked in that house. If some strange person had broken into that, page 2208, house and killed Theresa for whatever reason, that house would be ransacked. They would have stolen everything they could have gotten their hands on, but they didn't because that's not what happened. What happened is Tom Lane broke into that house, and Tom Lane went into the bathroom, and Tom Lane killed Theresa. And he was coming out of that bathroom right here, and he was going back through Indy's bedroom right here, and right on top of this dresser in plain view is her jewelry and some cash. Remember, that's what she said? Right here is her dresser. He has to walk right by there. Too easy. It's right there. And then in pencil, he writes, why would I not take Theresa's stuff that I got her? And then he goes on to say, it's right there, and he grabs it and he leaves. And he goes back to his house, takes between 17 and 20 minutes to get back to his house, and it's happened within an hour. And at 9:30, he's back at his house. At 9:30, he's back at his house. At 9:45, out with the old, in with the new. He changed his screensaver, and he's got his new Lorna Abe on his screensaver. And this is absolutely what the Brunos say they saw. Now, the defense wants to make a big deal out of the overflow valve. But I submit to you, ladies and gentlemen of the jury, the overflow valve was, page 2209, was working exactly how it was designed. And they want to show you this picture of the overflow valve that is not the overflow valve. Remember, on this particular tub, the overflow valve, I submit to you, ladies and gentlemen of the jury, looks different on this tub. And there's been numerous photographs that have been admitted of the victims, Theresa, in the tub. And you'll have to look at, and you'll have those to look at, ladies and gentlemen, and you can see for yourself. Make no doubt about it. Mitch McRae, plumbing on the side jobs with Mobile Sheriff's Department, and the defense said that that water would have had to been run in 2 hours. No, absolutely not. That water would not have that water would not have run that long, because the first person that comes in that house at 10:10 turns it off, and the overflow valve has worked. And not every single person that comes in that house says, and then there's two dashes. Every single person that comes in that house says that there is not any water on the floor. Not once has the tub overflowed, because the overflow valve was working exactly like it was designed. Now they want to say, oh, her hair was clogging the overflow valve. Dave Lott, the page 2210, investigator of the Alabama Department of Forensic Science, and Krostowski with the Alabama Department of Forensic Science, they removed the body. Not once did they ever say her hair was clogging the overflow valve. Not once. The overflow valve was working just like it was supposed to. And after the water was turned off, it was continuing to work exactly like it was supposed to, because the people that came in, Indy Wilson, Iris Rayleigh, Deputy Leddick, Shane Strangler, all the people, one by one, that came in, all said they heard the water leaving the tub. They heard the water leaving the tub. It was working exactly like it was supposed to. And then when Dave Lott got there, it was 6 inches down below the overflow valve, because it had worked exactly like it was supposed to. The defense wants to say that there was more water going in than coming out. There's absolutely no evidence of that. Absolutely no evidence of that. You know the chain when the defendant... You know the chain when the defendant pried the piece of wood off the door and realized he couldn't get his chisel right there because the screen door piece of wood was still on there, and he, page 2211, went lower, okay, and he popped the door open. There was a chain on the door. There was a chain on that door, and the chain was latched. And when Lark says he kicked the door in, he had to break the chain in order to open the door after he had gotten it pried open with the chisel. So yeah, he put force on that door and he popped the chain. And in fact, we didn't find that the plate with the 3 screws, but we found one of the screws when he popped it off the door underneath the couch. If you recall, it's in evidence. And that's what happened. He had to hit that door to pop the chain off. The chain popped off, the screw went flying under the couch, and he got to Theresa in that bathtub. And Dr. C, Theresa died a violent death. There's no doubt that Theresa Lane died a violent, horrible death. She had defensive wounds over her entire body. She was drowned in a bathtub with water full force, water being shoved in her face. You know, we talked in Void Dyer, and I asked you a number of questions about 2 weeks ago about direct evidence and circumstantial evidence. And page 2212, the judge will tell you that direct evidence carries the same weight as circumstantial evidence. And if you recall in Void Dyer, I said there's no eyewitness to this crime and there's no videotape to this crime. And I asked you, could you do your job as a juror, and would you require an eyewitness to this crime, or would you require videotape of the actual murder? And each of you were there, and y'all said no, you would not require it, because that's not what the law allows. And that's not what the law allows, ladies and gentlemen of the jury. But you know, we have a chisel, we have the chisel, and we have all the evidence that we have presented to you, and all of that evidence proves to you that Tom Lane committed the capital murder. Tom Lane committed this capital murder. Not just murder as the defense wants you to find, but capital murder. And not just one count of capital murder, but 2 counts of capital murder. 2 counts of capital murder. Now, I did tell you in opening statements, I did not say money is the root of all evil, because that's not what the saying says in the Bible. It says the love of money is the root of all evil. Page 2213. And the defendant had lost his gravy train. He was getting unemployment. His wife's paycheck wasn't getting deposited into their joint account because they had split up and he didn't have that money. He was not working. Neighbors in the trailer park said his car was there all the time. He couldn't live off Theresa anymore. He didn't have any money in his checking account. And in fact, not only did he not have any money in his checking account, he was in big debt. He was in big debt. And if you look at all the bills that were admitted in this case, for example, his singular wireless bill, he was past due $391.55. And after you added the past due bill with the October bill, he owed the phone company $511.55. And then Tom writes, but I got it reduced to $200 by something, a plan that something. He was past due on his wireless account. I'm sorry, that was his wireless account. He was past due on his landline and had an outstanding balance of $1,021, of which $335 was past due. He had numerous credit card bills and are in his folios, and things were seized during a search warrant of his car and his truck. And he owed thousands and thousands of dollars in credit card debt. And he was hurting for money. There is, page 2214, no doubt he was hurting for money. And you know, he knew we brought to you Ronnie Williams. And here we showed Ronnie Williams and asked Ronnie Williams if the defendant, Tom Lane, was served with the date of his divorce trial. And he said, oh, absolutely. He was served with the date of his divorce trial. It was January 7th of 2004, and then Tom marks it out and put October the 15th of 2003. And that just wasn't good enough for Tom, because he had already bought his ticket to the Philippines to get his new mail-order bride, Lorna Abbey, in December. He had already planned for that, and he was making all those payments to her daddy so he could get her, and he was making those payments in July and August and September. And he was making those payments, and he was out of money, and he didn't have any more money, and he was overdrawn in his checking account, and the divorce just wasn't moving fast enough for him. You know, a January 2004 divorce trial would mess up everything for him. It would mess up everything for him. And he knew that Theresa had gotten life insurance on the day after that she was hired at Walmart. He knew that, and we proved that he knew, because if you remember, Miss Debbie Gable said, I gave her the beneficiary paperwork on the first day, and she filled out her forms, and she decided she wanted to take it home. And it was $10,000 of life insurance and $10,000 of accidental death and dismemberment. And she took it home, and she brought it back the next day. And then Tom wrote in pencil, not something, I don't know, the comb vent lost it, something. She took it home and talked to Tom about it. And she brought it back the next day, and it had been changed. And it was $10,000 life insurance. But the accidental death and dismemberment had been raised to $150,000. And she turned it in on day 2. And when she realized that her marriage was over and she had moved out of the house and she had sought the advice of her attorney, Ronnie Williams, and she went back to Debbie and said, I need to change my beneficiary. And that is exactly what she did. But Tom didn't know that. Tom, in his mind, knew that when she signed up for the life insurance, he was the beneficiary, and it was $150,000 accidental death and dismemberment. And we know that because after he killed Theresa, the very same day he killed Theresa, he goes to collect the life insurance. Now, the defense would have you think that there was nobody to bury Theresa. Nobody to bury Theresa. Well, from this paperwork, you can see, page 2216. Ladies and gentlemen, she had a sister, Miriam Mahoney, who lived in Tennessee, who she changed the beneficiary to get all the life insurance money. They had a good relationship, and Miss Miriam Mahoney was absolutely the person who should have taken care of the funeral arrangements and her burial arrangements, not the defendant. I mean, it was clear at that point he didn't like her. He didn't want anything to do with her, and they want you to think he's a good Samaritan by going to Walmart and trying to collect life insurance so he can bury her? That's preposterous. The evidence is very clear. The evidence is very clear. She didn't want to have anything to do with him, and he didn't want anything to do with her. He didn't want to have anything to do with her either, because he had already moved and he already had him a new mail order bride. He had traded her in. And what's really important on that day is he had $1,300 cash in his pocket, because if you remember, that was on the 12th. On the 13th, he paid Buzz Jordan $1,000 cash. And he had $300 when he was arrested in cash, okay? So he had enough money. The day he went to, page 2217, the day he went to the funeral home, he had enough money to just take that $1,300 and pay for her cremation. He didn't have to go get her life insurance money. He didn't have to. He had no reason to go and get her life insurance money, but he really did. But he really did, didn't he? Because he wanted it for his new life and his new bride. And he, in his mind, was the beneficiary. And old Debbie Gable How did he act when he came in? He was a fine, calm, rational. And what happened when you told him that he was no longer the beneficiary? Irate. Irate is the word she used, irate. I was crying and pissed of my wife was dead. Oh. Okay, so they're describing him as irate, but he writes, I was crying and pissed off my wife was dead. Tom Lane is not a good Samaritan who was wanting to bury his wife because she had no family. He is a greedy, self-centered, self-absorbed narcissist who killed his wife for her life insurance money. It is clear what he had to do. He had to get her out of the way. He knew she had the life insurance money. He thought he was the beneficiary. It was clear he was collecting what he thought was his. Women were property to him. And she, Theresa, had been bought and paid for, and she was expendable, and he needed to get her out of his way. Page 2218. Because the divorce was taking too long, and he had more property that he needed to buy in the Philippines, Lorna Abbey. And he needed money to do that. Out with the old and in with the new. And the evidence is clear. That is exactly what happened in this case. Tom Lane is guilty of murder during the course of a burglary, which is capital murder, and murder for pecuniary gain to collect on her life insurance money, and that is capital murder. And we are asking you, ladies and gentlemen of the jury, to find him guilty on both counts of capital murder. The court, all right, ladies and gentlemen, it's a little after 12. They are ready for you next door. I'm going to let you go to lunch, and then I'll charge you as the law in this case, and you can begin your deliberations. Have a good lunch. Lunch recess. The court, all right, let the record reflect that the fact that the defendant is here with his attorneys, jury present. The court, all right, y'all please be, and that's all. That's all I have. That's all that was sent to me. I'm going to just withhold my comments to myself at this point in time. And I'll just say that.